Good morning. A call to order the Cannabis Control Commission, recognizing the quorum of commissioners. Call the May 22nd, 2025 meeting to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Camargo, Concepcion, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a very full agenda today that I'll generally summarize. We will start with opening comments from commissioners, then we will proceed to staff license recommendations. There's one change of ownership recommendation, 16 license renewal recommendations, 2 final license recommendations. Following the staff license recommendations, we have 2 votes, a hearing officer recommended decision, and a request for equitable relief. We have 7 items in the commission discussion and vote section today: our draft governance charter discussion, agent registration discussion, a job description for the complaint resolution administrator, and the FY 2025 and 2026 budgetary impact, a legal intervention update, and then we have draft guidance on positive impact plans and draft guidance on equity, followed by our commission election of a secretary. We will take a lunch break at or close to 12:30 for about 30 minutes, but certainly invite my colleagues to ask for a break needed anytime before or after that lunch break. I will ask commissioners wishing to comment or ask questions during any part of the meeting to raise their hand to be recognized. Okay, with those initial comments, I will turn things over to commissioners for any comments or updates. Commissioners will go in alphabetical order. I'll give my comments last, and we will start with Commissioner Camargo.
Good morning. Thank you, Chair. I know we have 2 public meetings today, so we have a very long day. But like always, thank you to all the staff that does everything behind the scenes to get us here to these meetings in terms of paperwork, logistics, media, our administrative staff, and just very grateful to be here. Looking forward to today's conversation.
Commissioner Concepcion.
Good morning. Fair warning, my opening comments today are lengthier than normal, and they are completely dedicated to Commissioner Camargo in recognition of her final day, our public meeting here at the Cannabis Control Commission. So I say that before going into it. Bear with me, especially Commissioner Camargo, because I know you don't like things being centered on you so much. But I do have some things I wanted to say in recognition. I joined the Cannabis Control Commission on January 12th of 2021, which is, I believe, a week or 2 after you, Commissioner Camargo, and Acting Chair Stebbins came onto the commission. Before then, we've never met, but I've always felt like I knew you, like I always knew you. And I later learned that you make that same impression on a lot of people who come around you, just in general. You and I represent a lot of firsts here at the Commission. We are the first Black regulators on the Cannabis Control Commission, the first with really deeply rooted foundations in communities that were hit hardest by the war on drugs. I believe we were the first based in the city of Boston. And of course, we are the first with names that are so similar, Camargo, Concepcion, that people did and continue to use them interchangeably.
Yeah. True.
Yeah. As regulators on the only agency in the entire state that's required to, quote, develop policies and procedures to encourage and enable full participation in the marijuana industry by people from communities that have previously been disproportionately harmed by marijuana prohibition and enforcement, end quote. It comes as no surprise that the bulk of those shared experiences transcended into a lot of our work here at the CCC. I highlighted, and I want to highlight a few of those things that we've done together. Together, we pushed for the creation of more Corey-friendly employment opportunities for people who for years were banned by law from working in cannabis. Many of those people were the same who created the very industry that we have the opportunity and the ability to regulate. Together, we, after really lengthy multiple conversations with a broad range of stakeholders, We established some long sought-after changes for delivery licensees, the first license type ever specifically designed for equity applicants. And together we advocated for the creation of a statewide social equity trust fund as the inaugural initiative under the freshly minted executive and legislative outreach strategy, a discussion that ultimately led to the creation of Chapter 180. Keep in mind, I'm only highlighting the work that she and I have done together. There's plenty more that I know many of our colleagues can attest to, and there's so many staff who can thank you. Honestly, thank you for helping them along their journeys, both inside the CCC and beyond the CCC. I know you'd rather we go on as if this was just a regular meeting, but it's really important that we recognize your significance. A lot of those firsts I mentioned come with their own complexities. There are a lot of expectations that come with being the first. And on the other side of that coin, not so subtle prejudices, both of which are unfortunately par for the course. And through it all, you've managed to stand firm in your advocacy for people as a collective. You've said time and time again that this is not an ordinary job. It's a place where everyone here puts in a lot of work. We put a lot of pressure on ourselves to do as much as we can with really slim resources. And I've witnessed the hours that you've put in, and I've grown to admire how you always lead from a sense of community. I really wanted to be there in person today. It's hard to talk from a screen. But we started here with all public meetings occurring virtually. So in a sense, it's serendipitous that my goodbye is in the same format. I'm really bummed that you're leaving, but I know that you are leaving with a firm imprint on this industry, and I'm really lucky to have worked alongside you. Thank you for all you've done, what you will continue to do, and I will definitely be bothering you because there's no way I can't see you and say goodbye in person. But thank you. Thank you for the example that you've set. Thank you for the work that you've done. Thank you for everything that you've poured into so many people here at the CCC, and you don't talk about it, and you probably never will talk about it, but there's so many people who've gone beyond and expanded their careers because of what you've poured into them. And with that, I will close my opening comments.
Thank you, Commissioner. Appreciate that. Commissioner Roy.
Can I just say really quick? I just want to say thank you, and amen. And correct. And I'll see you somewhere in the community. And thank you so much, Commissioner Concepcion. It's been a privilege and an honor serving with you. I've learned so much from you and how you work. And you always say how your brain works, you know, how all of our brains work. But thank you so much. And I really appreciate it. Thank you.
Thank you, Commissioner. Commissioner Rowe.
Thank you, Acting Chair, and good morning, everyone. And I'll be brief this morning. I just a couple of items. And first, I want to acknowledge the announcement of the Equity Work Career Hub. So I want to thank, which for those that aren't familiar, it'll be a platform to help align folks in the cannabis industry with meaningful jobs from employers, and it'll offer other platforms, if you will, seminars, different things. I was noodling around last night trying to get a handle on it, but we've talked about this for a long time, and I just want to thank everyone at the commission who was involved in getting this up off the ground. Again, it's an Equity Work Career Hub, and for those that aren't familiar, there's more information on our website. And I just also want to take this time to recognize my colleague today. This is her final, although we did a double header for you, right, on the last day. Meeting with us, and I want to thank Commissioner Camargo for her public service, for her time and her tenure here at the commission. I've had a wonderful opportunity to get to know her very well. And I already missed her energy and enthusiasm, and you know, people don't understand the dynamic of our relationship, right, Commissioner Camargo? And you know, somebody once joked we were like Scalia and Ginsburg. We're like, you know, we're very good, and we talk a lot, and we always check on each other's health and to make sure we're doing okay, because this can be a highly stressful environment. And you know, and I want to thank you for your work that you've done around social consumption. And we started to work together on the public awareness, which we all fully understand what a key component this will be as part of the rollout of social consumption. And you and I always joked about that succession manual, right? We said there's no manual when we arrive, and there should be a succession manual when we transition. So, hopefully I can tackle that on some level. But I know we're going to stay in touch, and I know you're going to go on to do great things. And I wish you all the best in the next chapter. So thank you, Commissioner.
Thank you. Thank you, Commissioner Roy. And I know you and I have had so many conversations, like you said, about life, health, and this job, but I appreciate you. I've learned so much from you. We've had this conversation, right? You watch me, I watch you, and we learn from each other. We may not always agree, and that's okay. So, but I really appreciate our relationship, and thank you for your service here. I've always said thank you for the work that you've done with the seniors, and thank you for mentioning the equity, the equity hub. I believe they were in Amherst yesterday, and they have an event coming up in Lawrence. So maybe later on this afternoon we can just put some of those, put some of that information out. So thank you.
All set. Thank you.
Okay. Well, the benefit of going last is I can just say, because I'm within striking range of Commissioner Camargo, I can just say ditto to what my colleague said, but maybe I'll have more to say in our last meeting today. But no, just I'll miss my colleague. I will miss her energy and enthusiasm, but I'll share more at her official last meeting later on this afternoon. Just real quick, I want to thank obviously our team that helps us prepare for today's meeting. Lots on the agenda to get to, so and lots of new things that we have not worked through before. So I'm looking forward to a good, healthy discussion on a lot of the topics. Just a quick update since we got together last, few meetings on the Hill last week with lawmakers and staff. Thanks to our DGAP team for pulling those together as we continue to introduce our new ED around, as well as touch base on our budget and hear from lawmakers on other issues that they hear about as they go out and about and interact with the industry and folks in their community and districts. Yesterday, I had the opportunity to listen in on a webinar for the cannabis industry hosted by, I think, the law firm of Blank Rome on the topic of employee stock ownership plans. Very interesting, may offer some potential for the industry and business owners of a certain size. It was truly an informative hour and certainly an interesting development for this industry. So I know we've had some licensees that have pursued this option for themselves. And I think there's several ways which if we see more of this, it is going to have some direct interaction with, I think, our regulatory structure. So more policy work ahead. As I was thinking, listening to the webinar yesterday, though, I do want to reflect on the fact that one of the first projects that Commissioner Camargo tackled when she got here was to update our diversity guidance. And I went back to that diversity guidance yesterday, and one of the elements in that guidance was for licensees to consider, develop a, the idea or suggestion of develop a plan with creativity, think outside the box. And we wrote back in there almost now coming up on 4 years ago. And I'm just going to read part of it. It gets down to, we encourage licensees to think outside the box, including variations on best practices listed above, specialized training, mentorship for key employees, team building activities, and other strategies that will help support and retain the workforce that the organization has worked so hard to assemble. The last line was businesses should think creatively about additional alternatives such as employee ownership opportunities where team members can gain ownership and control or build financial equity in the company. So your last day being today, for official public meeting participation, coupled with that seminar and just reflecting on the work that you kicked off 4 years ago, greatly appreciate it. So just a final note, as we head into the Memorial Day weekend, reminder to express our thanks to the brave men and women who have made the ultimate sacrifice, and our thoughts and prayers to the family members they left behind, those Gold Star families, who we hope can feel some comfort comfort by the fact that their loved one's sacrifice continues to provide, excuse me, gonna tickle, provide the freedoms we enjoy today. So with that, we will move on to, bear with me, move on to our agenda. Jamie Wakefield is here, so we're going to go through staff recommendations first on changes of ownership. Welcome, Jamie.
Thank you for having me.
Of course.
There's one change of ownership and control request for consideration. The licensee is Castle Leaf LLC. They are seeking a change of ownership and control for 2 adult use licenses and are requesting to add 1 individual and 1 entity. Additional information is contained within the executive summary for the Commission's review and consideration. Therefore, Commission staff do recommend review and decision on this request, and if approved, do request your approval be subject to the conditions before you.
Okay. Any questions from commissioners on this proposed change of ownership? Also. So, if there's no questions, I'll seek a motion to approve the change of ownership for Castle Leaf LLC. Do I have such a motion, Commissioner Camargo?
So
Do I have a second, Commissioner Concepcion?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Camargo?
Aye.
Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 4 in favor, none opposed. All right, we will move on to staff recommendation on renewal of licenses.
There are 14 adult use renewals and 2 medical marijuana treatment center renewals for consideration. Commission staff recommend review and decision on the renewal applications before you, and if approved, request that the approval be subject to the licensee remaining in compliance with the Commission regulations and applicable law.
Don't have any conditions. I did have a couple of questions for licensing on one of the licensees, but they shared with me some of the RFI communications, and I feel comfortable that I don't need to attach a condition to the renewal, but we'll obviously keep an eye on that licensee for further compliance. Any questions on the slate of renewal licenses? Didn't get any conditions from anybody, so I think we're all set. Okay. Seeing none, I will seek a motion to approve the slate of renewal licenses. Do I have such a motion, Commissioner Concepcion?
So moved.
Do I have a second, Commissioner Roy?
second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Camargo? Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 4 in favor, none opposed. All right, we will move on to staff recommendation on final licenses.
There are 2 final license recommendations for the Commission's consideration. Commission staff recommend review and decision on the final licenses, and if approved, do request your approval be subject to the conditions before you.
Okay. Just for clarity, we're only voting on one because the second one, I think, is the reason for the second meeting this afternoon.
There, I believe there's a third.
Yeah.
Was there a third? Okay, sorry, my apologies. All right,
Evergreen Industries is the
Evergreen Industries. Thank you. Thank you. Okay. Any question on these 2 final licenses? Nice to see an MTC securing their final license. Any comments or questions? Okay, seeing none, I'll do a roll call. I'll seek a motion to approve the staff recommendation on the 2 final licenses, Hidden Wonders LLC and Native Sun Wellness Inc. Do I have such a motion, Commissioner Roy?
So moved.
Do I have a second, Commissioner Camargo?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, do a roll call vote. Commissioner Camargo? Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 4 in favor, none opposed. All right. Okay. I think we're all set, Jamie.
Yes.
That was tough.
So, but thank you.
Anything you'd like to say before you leave us?
I would love to say thank you to Commissioner Camargo for all the hard work throughout the years and helping to move us forward as an agency, and your advocacy. It's really admirable. Thank you.
Thanks, Jim. Appreciate it. Appreciate the work of the licensing and INE team as well. All right. Next item is the hearing officer recommended decision. And I will turn things over to our general counsel.
Chair, good morning, commissioners. On the agenda here today is consideration of the hearing officer recommendation, recommended decision in Nature's Alternative, which is the board books for review. Just by way of quick background, and I do want to just take a step back and talk about process before we hop into consideration of this request. In terms of process, I will refer back to discussion at the last month's meeting regarding the process to review and take action with respect to the hearing officer's decisions. One thing, and I'll encourage folks to listen in on the prior recording of the meeting for a more robust discussion of the process. One item that is a little bit different than what was discussed at the last meeting has to do with presence of the parties before you at this stage here. And you'll notice that the parties are not here today. And the reason for that is we did a closer look at the rules. We looked at the standard adjudicatory rules under 801 CMR. Also looked at our own regulations at 935 CM 500, 11C, and also looked at some regulations pertaining to sister agencies. And what we discovered is that our own regs do not provide for oral argument before the commissioners. Rather, the interaction is limited to hearing officer's review of written objections. So, and that's compared to the Gaming Commission, whose regs provide for an oral argument before the commissioners. So based on that review, we have concluded that there is no such mechanism available here at the commission for an oral representation from the parties at this stage. So just wanted to get that out there and make you understand that we really background as to why parties aren't here today. Turning to the matter at hand, this is a matter where there was a summary suspension order issued based on an unapproved change of control involving the licensee. The licensee did request a hearing on this matter. While the request for hearing was pending, the commission did review and approve the change of ownership and control application for the applicant, for the licensee. And on that basis, the licensee withdrew their request for a hearing. And at the same time, the PC submitted a motion to dismiss based on the same set of circumstances, that the change in control application having been approved remedied the situation that led to the original summary suspension order. So there is no disagreement here between the parties. They are both seeking a motion to dismiss, which the hearing officer has recommended in her decision. So for you here today is to review that decision and to take action with respect to it. The basic options available to you are to adopt and approve the recommendation. That's one option. Another one is to modify or amend the recommendation. Another is to reject or reverse the recommendation. And the fourth option would be to remand the decision for further fact finding by the hearing officer. And so with that, I'll turn it over to you to deliberate and to any questions that you have.
Commissioner Roy, go ahead.
Thank you, Acting Chair. Thank you, General Counsel. I just need edification on one paragraph. from the hearing officer. And it's in the board book, it's on page 101. So it reads, on February 24th, 2025, I sent the parties a ruling on motion to dismiss that purported to grant the commission's motion to dismiss. On March 26, 2025, I sent the parties a notice rescinding my February 24th, 2025 ruling, stating that the ruling should have been styled as a recommended decision for the Cannabis Control Commission, and informing the parties that I would issue a recommended decision forthwith. So could you just walk us through what happened there?
Yeah, just briefly, and going to turn it over to anyone else that may have more information about this, but my understanding is that the hearing officer originally styled her ruling as as opposed to a recommended decision. She styled it as a ruling, which would have exceeded her authority, so she then corrected that.
Okay.
Hopefully that answers the question.
So her role as a hearing officer is not to issue rulings, but recommendations, even moving forward. That's okay.
Yeah.
I thought.
Questions? Commissioner Concepcion, any questions?
No, no questions.
A couple of questions. GC, obviously, first time seeing one of these. I've had some experience dealing with these during my time at the Gaming Commission. Certainly appreciate, I guess, the new rules as you discuss them or change in process as well as kind of going forward. But the first time seeing this in the latter half of her recommended decision, actually on the last page, where obviously the party was seeking to make a request for a dismissal or withdrawal of the case, some clarity maybe on behalf of the complainant as to what they needed to do. Can we make sure, obviously going forward, again, this is all new, but there was, it appears there was a little confusion, getting an email from the complainant saying one thing and that not being a part of the official process to actually withdraw the complaint. So as long as we can clear these things up kind of going forward, I mean, learning process and, obviously not only for us, but, for anybody who decides to make an appeal to the hearing officer, just making sure that we note where more information or more awareness about the process can be shared.
Sure, understood. And I think, as you mentioned, a lot of the stuff will work itself out over time as we do some piece. Point taken.
Commissioner Royko.
Yeah, and just this document speaks to 801 CMR, both informal and formal rules. Could you delineate for those listening, and we will be operating under which set of rules under 801?
Yeah, so what I can say is that there are guidelines and requirements for which rules will be followed depending on the type of matter that is being appealed. And those are set forth in the regs. And the rules themselves, are set out in the CMR. So parties can get more information about what is required under each set of rules there. But the regs do set forth which rules apply in certain circumstances. Where the regs do not so identify which rules apply, the parties themselves, can work together and come to an agreement as to which rules they would like to see applied to. So long story short, there are certain circumstances where our regs prescribe that certain rules will be followed, and there are others where the parties are left to come to an agreement as to which rules they would like to see going forward.
Commissioner Camargo, you say you're also. And Commissioner Concepcion. You're all set? If there are, oh, sorry, go
No,
ahead.
no, I was saying I am in response to yes.
Okay, thank you, Commissioner. Thank you for those explanations, GC. Thanks for the questions, Commissioner Roy. I would now seek a motion to approve the hearing officer's recommended decision and direct the general counsel to take appropriate steps to finalize the decision. Do I have such a motion, Commissioner Camargo?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
And motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Camargo?
Aye.
Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye. 4 in favor, none opposed. Well, our first foray into that, and obviously helped by the decision of the complainant to seek a dismissal. So, all right.
Thank you, Commissioners.
Thank you.
Thank you.
The next item up is a request for equitable relief.
I will kick off the conversation here on this one. Before you hear is a petition for equitable relief filed by Deerfield Naturals. And you have some of the backing information in your packets. So I won't resuscitate or regurgitate what's already there. But just really high level, and then I've got EC here with me to answer any factual questions that you may have. And just to take a step back here, as you'll recall, this is a collaboration between the legal division and EC on these matters as they come in. The legal division initially looks at the submission to make sure that it complies with all the requirements. The required documents are all included in the submission. And then we refer that over to Enforcement Counsel and his team to look into the substance of the request and to make a recommendation. And then it's shifted back to you for your deliberation and vote. So that's where we are right now in that last part of it. So at this point, legal division has deemed that the request satisfy the requirements of our regulations. And then EC has now reviewed the factual backdrop and made a recommendation. And just in terms of what's at issue here is this licensee had been under the impression that they were going to get that the town of Deerfield would be willing to enter into a post-meeting agreement with them. Took certain actions, including paying licensing fees. It turned out later on, or shortly thereafter, that the town notified the licensee that they were no longer to entertain those discussions, and it cut off further discussions to that effect. This petition followed, and while the petition itself listed 3 different types of equitable relief that they were seeking, in further discussion with EC and his team, they subsequently modified that to focus in on one of their requests, which is a refund of the license renewal fees that they paid. On 3 different licenses, there was a retailer license, a cultivator license, and a product manufacturing license. In total, there were $25,000 in license fees paid that are at issue here in this equitable relief petition. I'll turn it over here to EC to fill any gaps that I may have left.
Before we go to EC, Commissioner Wright, you have a question?
Thank you, General Counsel. Thank you, Acting Chair. Before we go to EC, I'm requesting a 10-minute break because we received the addendum at 9:47 a.m. this morning. And before EC presents, I really need to read this addendum. So if we could have 10 minutes to do that.
Yeah, well, we'll take a little bit longer. It's 10:45 right now. Why don't we stay in a recess until 11 a.m. That should be able to give.
Thank you. I appreciate that. Thank you
enough
very
time
much.
to Meet up with these enforcement council.
Commissioner, are you gonna print it or read it on? I was gonna read it here, but you want to print it? I can print it. Yeah. I've been struggling with board of this.
Yeah.
I'll try 3 copies. Can I print it in here? Yeah.
Commissioner Concepcion, you back with us? Yeah. Board effects didn't kick me out yet.
I think it's the answer.
Sorry. No, it is my
Apologies, everyone, I'm here.
They don't melt my microphone. All right, we are reconvening. And I think we were turning it over, before the recess, we were planning to turn it over to our enforcement council. So I'll invite our enforcement council into the discussion of this first application for equitable relief that the commission has considered. Go ahead.
Thank you, Acting Chair. And General Counsel provided a thorough overview of this matter, so I don't have too much to add on to this, but happy to answer any questions if, as the board has them, and that I can answer.
Because enforcement council, we got your memo was shared. I think we just got it this morning. Do you want to walk just through the highlights of this? If we took a break, I know to confer with you on, but give a chance for the public to understand what was in the nature of the update.
Yeah, absolutely. And so I'm happy to speak to that. So this is what you all received this morning, and apologies for the delay on that. This is an addendum to the recommendation that was in the board packet for you all. So in the recommendation, we provided 3 options for your consideration. And in addition to that, or we attempted to make outreach prior to actually submitting this for your consideration. We did not make outreach to the licensee. And so we did not hear back from the licensee prior to the first submission, which is why we supplemented that with the addendum that's before you now. So after getting in touch with the requester here, we were informed by the requester that at this time they're no longer interested in the options articulated under number 1 and 2, namely the extension of their licenses without a prorated fee and a waiver of the change of location fee. So at this time, they are only interested in consideration of the 3rd option, which would be granting a refund of the annual license fees that were remitted by Deerfield Naturals in association with their applications to renew those licenses.
And just for discussion, you remind us of some of the timeline to this, when they paid, when they were supposed to renew, when they got notification from their host community that they didn't want to.
Of course. So the payments, there were 3 licenses at issue here, but the timeline is the same for all 3 of them. So I will just kind of summarize them together. So there was a marijuana cultivator license, a marijuana product manufacturer license, and a marijuana retailer license. So the licensee in this instance submitted their application and payment, or their renewal application and payment, on August 20th of last year. They paid by check, so that was received by the commission's lockbox. The next day, on August 21st, the town of Deerfield issued a letter to the licensee indicating that it no longer intended to continue as a host community for the licensee. And the actual, there were a couple of town select board meetings that occurred after that. There was one on August 21st, which Deerfield Naturals was on the agenda for. And then there was a follow-up on August 23rd, which was solely focused on Deerfield Naturals. I believe the bulk of the conversation regarding that licensee happened on that August 23rd date. The licensee then submitted their request on October 16th, 2024 for equitable relief. And that was just 13 days prior to their expiration date. So all 3 of these licenses expired on October 29th, 2024.
And just for background information. Do you happen to recall? I don't see it in the write-up for the request. They were only in the provisional license phase. Do you happen to know when they get their first provisional license approval?
Yeah, that is correct. All three of these are provisional licenses, and they received provisional licensure for all three of these licenses on July 29th, 2020.
For me, I'm happy to start off the conversation. I don't know if my colleagues want to jump in. Oh, sorry, Commissioner Concepcion. Go ahead.
I'm happy to go after you if that's your preference.
I'm happy to defer to you if you want to go first. Go ahead.
Okay. I had a couple questions for Enforcement Council. So based on that memo, I just want some clarifications. One, that I wanted to clarify if the recommendations from staff have now changed after receiving that information from the licensee. And then the second is if there are any additional details in terms of the rationale for only wanting to pursue that third option. I'm assuming that they no longer wish to go down the process and being licensed, but I just want to make sure I'm understanding this correctly.
Yeah, thank you, Commissioner Concepcion. That is my understanding as well. This is really, the addendum is really intended to just supplement the initial recommendation. I think that it does make sense that if what we wanted to do in terms of that outreach, or our rationale for performing that outreach, is because there has been a period of time that has elapsed since they actually submitted their request. These licenses also expired, so we did want to just ensure that before the board does consider this matter, that the requester was still seeking the same relief. So after reaching out to them, they informed us that they were only interested in the third option. So I do think that our recommendation kind of follows based on that. And I will say too that the recommendation here is really couched as you may consider this option. I do think that based on our regulations, there are 4 options that are specifically identified. This does not fall into any of the 3 specific options. It really falls, in my opinion, under the 4th other relief that may be granted at the Commission's discretion. So the recommendation here also speaks more to if the Commission elects to grant the relief, the staff's recommendation is on a potential condition relative to that refund as well. So here, our recommendation would be imposing a condition to require surrender of all licenses prior to the issuance of any refund if the board wanted to consider exercising that option. But insofar as it relates to kind of the Commission's authority to do any of this, I would definitely defer over to the legal department in their role here.
Tim, rephrase that a little bit. So instead of the original recommendations, the recommendation now from staff is the third option, and that is sort of a reimbursement. Is that correct?
So I would say we're not specifically recommending that you reimburse them. We are really more passing along that request from the licensee, and our recommendation is in terms of how you might want to proceed with that, or conditions that might be appropriate based on their request. So we are not giving you we're not saying we recommend taking this action or not taking this action, at least in this document right here. We're recommending options or considerations for how you might want to go about that if you choose to exercise your authority here.
So, Chair, if I may.
Of course, go ahead.
Okay, so in the original document for the request for equitable relief, there are 3 recommendations, recommended actions given to us. You know, one was around, I won't specify everything. I think everyone has the documents in front of them. Is that document still relevant? Are we still using that as sort of the recommended actions from the team, or has it been amended by the additional information that's been received?
Yeah, so I would say that the original recommendation is relevant insofar as it outlines the applicable facts here. It gives you the background information. The three options that are identified at the bottom, the staff recommends consideration of those three options, but it's really up to the commission's discretion in terms of what option you want to exercise. And our recommendations were more focused on if you were to exercise your authority to grant one of these options, here are some recommendations in terms of how you might want to either set some parameters or boundaries on those recommendations. So, for example, limiting it by imposing a reasonable deadline for the licensee to act on it so that it is not a kind of an open door with no specific end time. And in this instance, so I would say that based on the response that we got from the licensee, since they are only interested in the third option, I think the commission might want to only consider that third option. Just based off of I would view this more as an amendment to the request from the licensee and us providing you with that information for your consideration here.
Thank you.
Yep.
Thank you, Commissioner. Yeah, for me, I mean, real quickly, again, go back to the case that this is the first case that we're seeing. This is as a result of the changes to Chapter 180 when there were expectations, as we've seen, where the marijuana establishment could not reach an agreement with an existing host community. This is obviously a license that has been out there for a while. It has been a provisional license now. Couple of months, it'll be 5 years. And obviously, I think all of us are aware that this is, opening up a marijuana establishment of any size is sometimes it's certainly costly, but it's also a lengthy venture. When I first looked at the original recommendation with the three options, the thought that occurred to me in those first two options being extension of the license expiration date with no fee, waiver of change of location fee, those boxes were kind of checked. I was looking at that as this applicant may choose to, now that one community has closed the door, they may choose to pursue their venture someplace else. Even within that context, my thinking was, okay, I'd want to put some time constraints around that, like how long we would keep that opportunity for relief available to them. For me, as I read this though, seeking the last form of relief seems to be at least to me, is an indication that we're not taking advantage of the extension of our license expiration date, and we're not seeking a waiver of change of location fee. Sounds to me like this is it. They're done pursuing any future business opportunities, and certainly, the door is closed to them with respect to their current host community. So that's the indication I get. Now the question, for me is, do we have the ability to, reimburse them for the $25,000 that they paid for their provisional license renewals, which we received payment prior to literally the day before their host community informed them that they no longer wanted to pursue a host community agreement discussion. I guess one other question I might have is, obviously other licensees have gone through a request for an extension process. None of that exists here. Nobody, maybe because of the definitive nature of the notice from the town, that opportunity doesn't exist. But just to make sure that we haven't, no requests for extensions were ever filed, anything like that, within the context of their hope to maybe re-engage with the community in a new OHCA. It sounds like this was a little more cut and dry. I guess the question that I come back to is, do we want to, return their $25,000? If we do, what is the process and the procedure for doing that? So that's kind of my thinking at this point right now. Commissioner Roy, go ahead.
Thank you, Chair. I'm not sure which side of the court here it's going to go to, but I have a few questions. Number one, I think this would be for EC. Was there a mutual abrogation executed?
There was not a mutual abrogation agreement. There was a letter from the town of Deerfield that indicated that they were ending their relationship with the licensee.
Was the letter sent to the commission, or was the letter sent to the provisional licensee?
The letter was sent to the licensee, is my understanding, and I'll just read the last sentence of this letter as well. So it states, please consider this notice under 935 CMR 500 183C5 that the town of Deerfield no longer intends to continue as a host community for Deerfield Naturals and notify the CCC accordingly.
Did we, in our due diligence, confirm authenticity of the letter?
It is on the town of Deerfield letterhead. It was discussed at the town of Deerfield public meetings. We did not reach out to the town specifically to confirm that, but the licensee provided this with their request, and we did also review the select board meetings as well, just to verify that the conversation actually was occurring as well. But it is my understanding that the town and the licensee did continue to engage with each other even beyond this letter, which I think, I mean, this is just speculation on my part, but I think that is why the letter reached the licensee in August and we did not receive a request until October.
There is a link to the select board meeting, which is on YouTube.
Was this a general applicant?
Yes, that is my understanding. I can double check that for you though.
Okay, and I have another question, and this might be for Director Coble. How many mutual abrogations or letters of discontinuance due to non-negotiations or discontinuing negotiations have we received?
Yes, so I know that Director Coble is out on vacation. I think as we're speaking in this conversation, I defer to GC in terms of kind of how we should discuss other matters that aren't related to this specific one. Just as it relates to this one, we've only received.
It is related in the sense that if there are other similar situations, this is a case of first impression, if you will. This will set precedent, if you will. And I'm just curious on average, how many letters of, or how many mutual obligations or letters of discontinuance we have received with similar circumstance.
Gotcha. Okay. Thank you, Commissioner Roy, for clarifying that. To that point, I'm going to defer over to GC because the legal department actually addresses that first threshold question as to whether a letter was received or there was a mutual abrogation.
Thank you, EC. Just, I can offer that there have been a number of equitable relief applications submitted. I don't have an exact number. I'll try to get that for you, but it is in the neighborhood of between 5 and 5.
Helpful.
Go ahead.
Okay, my question is for, oh, I'm sorry, through the chair.
Oh, go ahead.
Sorry. Thank you, Acting Chair, and sorry, Commissioner Roy. Just wanted to confirm, yes, all of these are general applicant. So just verified that here.
So actually, I just want to highlight, and before I have a question for CFAO, under 500-05 and fees, my interpretation, and I guess it's open to interpretation, on 1A is marijuana establishment application license fee. Each applicant for licensure as a marijuana establishment shall not may, pay to the commission a non-refundable application fee, annual license fee, and to the seed to sale SOR provider. So I read this as conjunctive, not disjunctive, that this is a non-refundable fee. So the proposed equitable relief would be contrary to 500,005.
Go ahead.
Lisa, I can't find anywhere in our regulations where there's a mechanism for us to direct to the marijuana regulation fund to provide a refund. I can't find it anywhere in our regulation. So is there a mechanism for that? Is this ironclad? We're 100% sure there is a mechanism. Is this, as treasurer, is this an expenditure? Is this a payable? How is this classified?
We do have a SOP that was signed, and this is internal, in February of 2022, that allows for 3 reasons to refund a fee. And basically they're in reference to errors. So if someone double pays, so there is a mechanism if they pay the wrong amount or if they pay an error, which
None of those apply here.
none of those would apply.
So it's contrary to the SOP.
It's contrary to the current SOP, yes.
So we have no SOP in place that provides for this.
That's correct, but I think this is the first time this has been addressed. But you're absolutely right. There's not an SOP that this situation would allow for us to refund revenue.
And do we anticipate any issues with the comptroller, legislature? If we go outside, there's nothing prescriptive in our regulation. There's nothing prescriptive in statute, and we have nothing prescriptive in our SOP. So we are winging it.
I would leave that interpretation up to legal.
I'll just add that we're the board to entertain this request, that the current SOP as it's drafted does not allow for such a refund. It would be revised and updated to allow for a refund in the situation of an equitable.
Also, I don't know if anyone has interpretation. I read 500,005 as conjunctive, not disjunctive. So if everyone can take a look at 500,005 1A, each applicant for licensure as a marijuana establishment shall pay to the commission a non-refundable application fee, annual license fee, and the seed to sale SOR provider. I can't think of another agency or institution that someone makes a business decision to no longer stay in a particular industry or field that it's the license fee is refunded. If anybody has an example of that, I'm highly curious.
Anybody, was there a response or anybody?
I might throw a lot of, there might be a lot of different responses.
No, I just wanted. Good point, but Commissioner Camargo, go ahead.
Thank you. Commissioner Roy, I had all the same similar questions in terms of process, SOPs.
Yeah, thank you, Commissioner.
And obviously we're having this conversation. It's the first time we're having it. My recommendation is to put a type of motion. I don't know whether folks entertain it or not, but to look into our processes first and our SOPs. And what this looks like, not just for this licensee, but for everyone who will come behind them. And internally figure that out quickly of what other means, because I think when we were doing chapter 180, folks, we worked through that really quickly. I don't think anybody expected what other meant internally. And we have lost some members that were part of that working group and also had institutional knowledge of this possible other process. And I think that it's a good time, and I know they've waited a little bit. Unfortunately, they may have to wait a little longer. But I'm curious how you all feel about that. Executive Director, Kajo, my fellow colleagues as well, because this will set precedent at the commission.
Commissioner Roy.
Thank you, Commissioner Camargo. I agree with you. I feel like we're putting the cart before the horse here. We don't have everything in alignment to do this. And I feel as treasurer, I have a fiduciary responsibility here, and I don't feel like we have everything, all the mechanisms in place to be able to execute this properly. So I agree with Commissioner Camargo.
ED.
So think I was understanding Commissioner Camargo's point to be that the leaving today would probably be the discussion that comes back to the commissioners in the future on how this may look if it were able to be moved forward on the option 3, specifically the other 2 in terms of waiving. I think in this particular instance are no longer viable for the actual applicant. And so it really, for number 3, would be talking about the SOPs, aligning them if an SOP could be drawn up within the regulation. And, you know, I think just from my perspective in sort of conferring with the CFAO and others would be certainly there cannot be a scenario if the commissioners were wanting to go forward with the option 3 that we're kind of discussing here. The commission, if it were able to work out an SOP that was amenable to everybody and was interested in pursuing number 3, the budget could not handle a refund or refunds in this scenario. So it would require that we also work out, to Commissioner Roy's earlier point, that everybody else involved in the MRF was also amenable to an SOP. We cannot have fees coming into the agency, going to the MRF, and then us out of our budget refunding. So there's external stakeholders here as well, which I think was discussed. And so I think, as Commissioner Camargo mentioned, that is sort of what I view as the next step, which is a review of what our existing SOP is, which exists, as the CFAO mentioned, because there are instances where a refund has to come directly out of the MRF in a double payment scenario, as the example that the CFAO gave. This is, if we're able to roll this into an SOP, there are other stakeholders we'd have to engage, and then we would bring that back to the commissioners is how I would see next steps.
Commissioner Camargo and then Commissioner Roy.
Thank you so much, Travis. Thank you. I would also push a little bit while if we accept this, while we're doing that, to go back. I know this will put a little bit of work on someone's plate, but to go back and look at the minutes or the meetings on Chapter 180 when we talked about equitable relief, specifically under other. Because I know we had a lot of conversation around this, and I think it's a perfect example of, you know, us creating regs and, you know, having to create them and then putting something in there and then now kind of, you know, facing it. So it's a good opportunity to kind of go back really quickly and kind of just maybe get some of that historical intent from the conversations around Chapter 180. But I would just add that as well.
Thank you, Commissioner. Commissioner Roy.
Thank you, Commissioner Camargo. I have a couple of requests. The SOP around the being able to refund through the marijuana regulation fund. Did we work in conjunction with other government agencies? Were there, to the ED's point, were there sign-offs or meetings needed to be had with other folks who touch the marijuana regulation fund, who oversee that? Also, I'd request, based on general counsel's saying there could be 5 to 10 more, I'd like to see a financial impact analysis. In other words, let's say worst case scenario, there's 10 and 10 also request the same equitable relief. What's the financial impact? Whether, you know, obviously we all agree it can't come out of our operational budget, but if it came out of the marijuana regulation fund, what is the financial analysis and impact if all 10 say yes, and this could open the door, the floodgates, if you will, for more folks. So we need to have really an understanding of what this could look like if everyone is requesting that. Thank you.
Thank you. Yeah, I echo the similar sentiments of my colleagues. You know, first of all, start with step 1. If we were allowed to do it, our SOPs would need to be updated. And I think the ED pointed out correctly that involves some other conversations. Again, I haven't echoed this before, I'd echo it now. You know, the concept of equitable relief for a licensee, any licensee who has put in a considerable amount of financial resources to getting through this licensing process. I don't think we'll ever be able to find ourselves in a stage of being able to give equitable relief, probably with what the definition or description would describe. That said, you know, my suggestion would be table this item. Obviously, as I'm thinking through the conversations, I would like to bring it back up at the June meeting. This is somebody who's paid within the current fiscal year, and we're quickly winding down the fiscal year. So if there are steps that if we decided to make it, I'm not suggesting anything, if we decided to make it, we would, one, need to update our SOPs, it sounds like, and have those conversations, but I would recommend we put this back on for our first meeting in June. Again, if that's our intention, is to help them get, suggesting either one, if we have the opportunity and we decide to go that direction to get the money out, it would probably make sense to do it in the current fiscal year in which it was paid. And, you know, again, they are asking this as under that catch-all, any other equitable relief is provided by the commission.
Acting Chair.
Yep, hold on just a second, Commissioner, I see your hand up. Yeah, sorry, that's my thinking at this point. Go ahead, Commissioner Concepcion.
My apologies. I spoke up in case you couldn't see me, but I wanted to first just note that I'm in alignment with the board's thinking in terms of gathering more information and holding off on making any sort of determination today. And you were going in a direction I was thinking through as well. I wanted to ask the enforcement group as well as our GC if there's any temporal components we should be aware of. Is there something that might be time sensitive that we should keep in mind? I just want to make sure that we're mindful of any other factors that may not already be top of mind.
I'll kick it off here, Commissioner Concepcion. From my perspective, I don't sense a time deadline, as it were. Acting Chair's point about any kind of refund being made in the same fiscal year as the payment was made, makes a certain amount of sense. But from a legal perspective, I don't sense a time requirement here.
Anything else, Commissioner? All right. I don't think we need to seek a motion. I think we can table this agenda item, but I would invite that. I think you have a good sense of questions, concerns from commissioners, but let's plan to bring this back for the first meeting in June.
We don't need a motion to table, as we had to vote on the.
You feel comfortable? Would you prefer to take a vote?
I would think we should, since we had vote on the.
Okay. Then I would seek a motion to table the request for equitable relief from Deerfield Naturals, Inc. And table it until our first meeting in June 12th. June 12th. Do I have such a motion, Commissioner Clark?
So moved.
Do I have a second, Commissioner Concepcion?
Second.
Okay, motion made and seconded. Any further comments or questions? Do a roll call vote. Commissioner Camargo, Commissioner Concepcion,
Aye.
Commissioner Roy,
Aye.
and Commissioner Stebbins votes aye, 4 in favor, none opposed. Good conversation. This is first time we're tackling one of these, so and appreciate all the work that staff has done to put into this application and reviewing it. All right. I think we now move on to commission discussion and votes. I will ask, unless there's any disagreement, I'm happy to, I've been asked to set aside the governance charter discussion until after our lunch break. So commissioners can have a chance to review some information and ask the ED any questions. So if that's okay, we can move on to set that aside for right now and bring that up after lunch. We'll move on to the next agenda item after the governance charter. Agent registration. All right, this one's on me. You can go to the next slide. Agent registration. I'll kick off the conversation and then certainly invite some comments and discussion as we go through this. All of us have heard concerns and frustration of the current regulatory burden of agent registration requirements. As we consider as a board adding additional license types through the new social consumption regulatory framework, working with this social consumption working group, I felt it appropriate to kind of bring this topic back up. What we want to discuss today are potential changes the working group will be bringing back forward with a revised version of the social consumption regs. I think the time is right with respect to these new regs, as well as needed changes for the industry to make some changes to our agent registration regs. Additionally, I want to bring up a topic of mutual concern. This is a topic of mutual concern with our colleagues in the legislature. And as we have discussed, collaborating with the joint committee and mentioning to them that if there are legislative topics that we feel we can address as a regulator, we want to take the opportunity to address those. What I want to use today for is to share the working group's thoughts, my own, and to certainly invite your thoughts and comments as well. Obviously, you will see new written regulatory language when we bring this back before the full commission. So just going through this current slide, I want to discuss the ongoing regulatory burden. I also want to look at a place where we should align our regs with some of our other agent registration requirements. I then want to raise the idea of discussion of a new registration type, and then would welcome some discussion around future changes to help address the opportunity to help an industry employee stay within the industry in case of a layoff or a closure. So these last two items are both for kind of near-term development. First two items are for more near-term development, and I want to get some industry feedback from industry stakeholders. So if we can go to the next slide. There we go. So this is what I believe is kind of an ongoing regulatory burden. We've all seen this language. This is current language under 935 CMR 500.030. Registration of marijuana establishment agents. Section 8 says a marijuana establishment agent affiliated with multiple marijuana establishments shall be registered as a marijuana establishment agent by each marijuana establishment, and she'll be issued an agent registration card for each establishment. I think this is the argument that, and the concern that has been raised to us multiple times. This is language that I want to propose that we change as we move ahead with our current work around social consumption. Again, we know the challenge currently exists, the regulatory burden currently exists. If we move ahead with social consumption where we're adding additional license types, this will continue to be a burden. I think the time is now to address it. We can go to the next slide. This is just kind of bringing the topic into align agent registration regulations kind of across the board. I'm sharing with you existing language that we have around 500.029, which is registration and conduct of laboratory agents or ITLs. A registration card shall be valid for 1 year from the date of issue and may be renewed on an annual basis on a determination by the commission that the application for renewal continues to be suitable for registration based on satisfaction of the requirements under 935 CMR 500.800, 801, and 803. We have subsequent language literally in the next section around the marijuana establishment agent. Again, 500.030, registration of marijuana establishment agents. Number 5 says an agent registration shall be valid for 1 year from the date of issue and may be renewed thereafter on a triennial basis on determination by the commission that the applicant for renewal continues to be suitable for registration. It's obviously pretty clear that we have, you know, a different set of circumstances for a marijuana establishment agent that they can renew on a triennial basis on determination by the commission. However, registration for a laboratory agent doesn't allow that same flexibility or that same opportunity. So again, a critical area where I think we need to draw some alignment with respect to agent registrations. If we can move on to the next slide. This is just some ideas, and again, welcome feedback and thoughts from my colleagues after I get through the next few slides. The notion of creating some new registration that may align with existing licenses and new license types. Floating the idea of floating a proposal of a temporary agent registration. And I go back to the hearing that we had with the outdoor cultivators last fall, talking about their workforce needs aren't consistent throughout the year. They really rely on a lot of support and staffing when it comes to their cultivation period, when they need to cultivate and harvest the product. They were looking for changes to agent registration that might allow them to keep somebody on for a temporary period of time where they assist during the harvest period. As we look ahead to our social consumption framework, in the possibility of a marijuana event organizer license, which has limited days available to it for a marijuana event organizer to hold events. A new license type or agent registration type might be also amenable to that license type as well. So thinking through a possible temporary agent registration good for a certain number of days, and perhaps with a lower fee for the agent registration than the current $115, which is for somebody for the full year. Again, just some proposals, some ideas for thought and consideration that I began to think about as we're working through the social consumption regulatory framework, as well as tying in the excellent feedback we got from our outdoor cultivators at last fall's listening session out in Great Barrington. If we could go to the next slide. Thinking more about agent registration and, you know, certainly what we see are the changing dynamics in the industry, where licensees might be facing closure, might be facing downsizing of their current workforce. My focus here is that we don't want to lose anybody who's interested in the industry and has invested a lot of themselves and their time and their education into getting a foothold and a job in the industry. So knowing that if I move from one licensee to another licensee by a different corporate entity, how can we best smooth that process so that somebody doesn't have to go for a longer period of time without a job in the industry? So my focus, or my just kind of introductory and where I'd love some feedback, is we have a goal that we don't want to lose people and lose industry workers. And the goal is how can that person quickly transition to another licensee? Talking with our division of licensing, the amount of time it now takes for a agent registration to be reviewed and approved is about 7 days. I think that's probably great, depending on who you are in terms of time. But I think that is it certainly is showing how much more efficient we've gotten with respect to approval of agent registration. So I think the licensing team for effectuating a more rapid turnaround with respect to agent registrations. But then the question becomes, what are the opportunities to allow that person to transition over to a new job with a new employer? Just giving some thought, and I think we can move on to the next slide, if I'm not mistaken. Providing that opportunity for continued employment, what are some considerations? Again, I talked about the agent registration timeline. There are still requirements around background checks, but there is also that agent registration cost that has been paid for somebody. I have thoughts and ideas, and again, these are kind of our, I don't want to say immediate, but hopefully near-term solutions that I would love for us as a body to think about. But thinking about that agent registration, if it's been paid and I lose my position either through a downsizing or perhaps surrender of, an ME's license, do we need to pass that cost along to another ME who's out there who might be interested in hiring the individual? So a lot of thoughts, but I just wanted to bring this up for discussion. I wanted to kind of give you some insight into where the social consumption working group is heading and some of the regulatory changes we might bring back attached to that social consumption regulatory timeline that we're in right now, and then some additional topics for hopefully the not too distant term where we can make some of these regulatory corrections to our agent registration process. So I think that was the last slide that I had, but appreciate the indulgence of my colleagues to let me go through some of those slides and just share with you my thoughts, but happy to open it up for conversation, comments, or questions. Commissioner Concepcion, go ahead.
Thank you, Chair. And first, thank you for putting us on the agenda, having this conversation. You are correct in saying that it has come across, my desk has come across my emails, my conversations for some time now that we tackle this issue. So I'm glad that we're having it. There were a few things that I've had in mind that I also want to include as some considerations. And again, I always welcome the opinion of staff and the team that are doing this on a day-to-day basis. But one of the things that I have brought forward in the past was around who holds that agent registration. So specifically, the idea of agents being able to hold their own registration. And the reason why I've thought about this is because it's a way to assist licensees who we have heard see at times frequent turnover. So they'll, pay for the registrations, they'll go through the entire process. And when it's time to continue with that hiring process, that person has decided to no longer continue employment. So they've already footed the cost of that and seen the financial implications of that. On the other end, for agents, it may be something that is helpful because it's a way for agents to deem themselves as being hireable beforehand. And you mentioned the background checks. The background check would already be completed. From a suitability standpoint, this is where it actually first came to my awareness, is when we were going through suitability regulations. There were at that point licensees who were not particularly clear on what our requirements were. So by allowing agents to have and hold their agent registration, that in itself verifies that there are no suitability concerns. So I just wanted to throw that out there. Those are some of the thoughts that I've had. And I do think it should be a part of the ongoing conversation to see if that is something that would work within our framework, or if there's some sort of adjustments we can make that are not too much of an overhaul.
Thank you. Thank you, Commissioner. Commissioner Roy.
Thank you, Chair, and thank you, Commissioner Concepcion. Thank you for putting this on the agenda today. And I think we all agree the current regulatory scheme is rather onerous. And I think it's time that we really do adjust these regulations. You know, having said that we've talked to many licensees, whether we're at an outdoor grow, where they have, like you said, mentioned in your presentation, where they require just temporary workers and to have really, and it makes it almost, I don't want to say impossible, but very, very challenging. And, you know, minimally, we need to bring our ITLs into parity with our other license types, minimally. We start there, but I don't know if our Director of Government Affairs and Policy is with us, Matt, or even Jessica. Jessica's in the back of the room. Have we looked at other jurisdictions? It's been brought to my attention that Colorado is every 3 years. There's one badge. So if I work for an employer that owns 3 license types, there's just one badge that kind of, so I don't have a fan of badges, if you will. So I don't know if we have a report or anything that we could put together to really look at what other jurisdictions are doing around that. And then kind of, you know, maybe we don't have to reinvent the wheel. Maybe there's one state doing a particularly good job at this. But I think we're all in agreement that we really do need to address this. It's really cumbersome and too challenging. And quite frankly, not business friendly at all.
I would agree. Commissioner Camargo, go ahead.
Yeah, no, I mean, I think this is a no-brainer. It's something that I think everyone has discussed. We've heard it. We heard it when we had the conversation with the outdoor growers out in Western Mass. And I think it will help, obviously. And Commissioner Roy, you said it. What was the last thing you just said? It's bad for business? Or?
Yeah, it's really not business friendly. I mean, we're going to jeopardize public safety. We're not doing that. It's just really not business.
Yeah, no, so I agree, and I'm excited to see it today. And Commissioner Stebbins, you're thinking of doing this and adding it to the regs when? Did you say that earlier?
My approach would be when we're the social consumption working group is currently working on updates, edits that they're going to bring back before the commission. What I would like to see at a minimum we bring back is the for this regulatory round where we're considering social consumption, that we make a change to 038, which is I work for one corporate entity. I have one license regardless of how many licenses. Obviously, we know that's a problem that exists now. We'll be compounding that problem if we add additional license types under social consumption. And I think while we're there, we ought to make the alignment work between ME agent registrations and the ITL agent registrations. So that I look is the more immediate things we can do. The other topics I brought up around a temporary agent registration and also looking at ways that we can, again, help effectuate a smoother transition for an industry employee to move to another ME if they get laid off or if they get, or the license gets surrendered. I actually want to try to find a way to put that out to invite some industry and stakeholder feedback on those two ideas. But I do want to jump back to Commissioner Concepcion's point because she brings up another topic that we've also heard about in terms of who pays, you know, and the opportunity for somebody to position themselves as a suitable, qualified, ready to go employee. It hasn't settled for me. I kind of go back and forth to, you know, do we want to leave it with licensees to figure that arrangement out for themselves with the employer, with the potential employees, such as, you know, you're here 6 months, I'll reimburse you, versus fine, you know, I'll take the risk and I'll pay it. I'll pay your registration fee, knowing the risk that somebody could turn around, leave tomorrow and decide maybe the career wasn't for them. So I struggle with that. I'm open to a discussion about it, but I still kind of land in favor of having the corporate entity essentially in a way being a sponsor to pay for the agent registration again and let them work out the mechanics with the new employee. But I do like the idea of how can the individual position themselves to be ready to go to work in the industry. The other topic, I'm sorry, this was the point Commissioner Roy brought up around the renewal. I think what we're seeing as the industry is maturing is that we are seeing more agents move to that triennial review. And I think that's reflected by what we're seeing is declining revenue going into the marijuana regulation fund for agent registration costs. More people are moving over to that 3-year renewal. So at a future meeting, when we bring this topic up again, I want to have a lot more of those details and facts and figures to share with all of you. But again, just wanted to bring this issue up. I know it's one we've all heard about. I remember Commissioner Roy and I going to visit a cultivator who had multiple licenses, and the agent registration fan was available for everybody.
Very cool.
Just a couple more topics and then we'll keep the conversation going. I think this dovetails nicely into where, and I'll invite the ED to offer his comments on this. We want to move to electronic badging of everybody. It is a cost to us right now. And again, we're going to do away with the fans. It'd be great to have the IT infrastructure to allow us to issue somebody an electronic badge that's available on their phone or whatever they carry with them. And it carries me to a bigger discussion, which we've also had conversations about. It's not necessarily specifically tied to agent registration, but re-looking at our RVT training requirements, and how can our RVT training kind of emerge into something that is more professional development than a yearly, have to go through the same curriculum. I've talked about this before at a public meeting. And by the way, this is no comment or commentary on the trainers that we license. They do a great job. We're the ones who are responsible for giving them the curriculum that they have to work with. So that's a lot, but obviously this is a topic that it's great to hear we have all been thinking about for some time. ED, go ahead.
Sure, I just wanted to provide additional context, and so kind of just putting in so everybody understands the buckets of some of these topics as we move forward. As the acting chair, the treasurer, the CFO, myself, and various conversations that we've had over the past few months as we talk about the budget and just issues in general with our partners in the legislature, we've been very clear, a solve on the issue that they also hear about at the legislative level as it relates to agent registration or badging. I think everybody is in favor of the process that the acting chair has described here. So we've just been clear to say, 12% of the non-tax revenues in FY24 that come in and go to the MRF, not the commission, is related to agent registration. That's come down from about $5 million to about $2.5 million, which represents 12% of those non-tax revenues in FY24. So we just want to be very upfront. We agree that it's important to address this issue, but there is a reduction in that non-tax revenue that I know a lot of folks pay attention to. So as we've had discussions, the treasurer, CFAO, acting chair, myself, and others, we just want to continue to make sure everybody aware that we all agree we want to fix it, but there is that impact. So, and that is not one that is directly our issue. So we're trying to share that information.
Yep.
And then, as the acting chair just mentioned, there are some other items, should we decide to sort of streamline this, find efficiencies, there are some things that we have to consider that will impact our budget. And as we're looking at currently 19.88 million next year, there is in a lot of these instances, you have to spend money to save money. And so to go on the electronic platform to do all these things, there is a cost to the agency to be able to have the IT infrastructure to be able to support those changes that then reduce for us costs of producing badges, those types of things. We'll have a similar conversation on the medical side about producing cards. So, all good points. I just wanted to make sure that people understand some of these are in the bucket of directly impacting us. Some of them impact the MRF, the funds that don't go directly to us. And so we're just trying to be as open and honest about those things as we try to find the right solution.
Yeah, no, and thank you. I appreciate those comments again. And it does speak to, bringing up this topic again. I saw it as a topic aligned with where we want to go with social consumption and the fact we'd be overlaying a whole group of new licenses. The collaboration and the partnership, we have with the joint committee and them being candid about issues that they're hearing about. And we certainly see, what issues are on their plate based on what gets filed. I do think this is an opportunity to make some needed changes. And we're just reminded again that the timing is right. But to your point, I think we do want to give a clear picture of what the impact would be. And going back to Commissioner Roy's point, people have said, well, what about other licensed professions that people pursue in the Commonwealth? And some of those, plumbers, electricians, ongoing professional development, ongoing license renewal, but they also start to build out 2-year or 3. I think the longest I saw was a 3-year period. So I think the people that we are moving over into the triennial review, and again, it points to why there has been a decline in the agent registration revenue. But I think that's consistent with some of the other professions in the Commonwealth, and we can treat everybody the same. But Commissioner Roy, go ahead.
Thank you. And I would love to see digitized cards. We all would, I think, right? And it's very aspirational, but you're right. We need to spend money to save money. So I appreciate that comment. And I just try to envision this, if we're able to make these changes. The Equity Work Career Hub, right? And, in other platforms, you have blue check certified. Imagine having someone green check certified, right? And I don't think it has to be a binary choice, like as far as who pays. I think it can be a combination. And I don't know if any other jurisdictions do this. And what I'm thinking is if the agent pays upfront to get certified, and in regulation, I'm just throwing this out there, after 90 days of employment, the licensee shall reimburse. So a problem we hear time and time again is we've invested in this person, we've invested in this employee, and they left after a week. And now we got to start. So putting in the time with that licensee would earn maybe that reimbursement. Maybe and that green check certification would follow this registered agent, and it would be, I'm just spitballing here, on our Equity Work Career Hub, you see people green check certified, but my goodness, they're already ready to go.
No, it's a good conversation. I definitely hear the point. We want people who want to get into this industry to pre-position themselves for success. And we have heard the conversations you pointed out. I invested a lot of time recruiting and training this person, and 2 weeks they walk away. May walk away for a lot of reasons, none of which have anything to do with the employee, may have to do with the employer. We don't know. I'm certainly open to that. I certainly, part of me would like to see the creativity maybe on behalf of the ME instead of us dictating too much to it, but it's a conversation I'm certainly interested in having. And again, my experience at gaming, there were a lot of people wanted to get in the gaming industry. Once they realized what the job is really all about, casinos are open 24/7, you're on your feet a lot, all of a sudden maybe the mystique kind of wore off. But it is an issue. So again, what I would suggest, or what I want to entertain, is when we bring back the social consumption regs, hang on just a second, Commissioner. When we bring back the social consumption regs, I'd love for us to be able to consider the first 2 tweaks in 0308 and 029, the ITL agent registration. And then kind of build out some conversations, questions that we can ask the industry into the kind of 2 subsequent topics, and find a way to fold in these other topics as well. So sorry, go ahead, Commissioner.
Thank you. This is helpful. And you got ahead of one of my next questions. I had a question and a comment, and my question was really about sort of next steps and what to anticipate. And the one thing I just want to add is that we, if it's possible, to gather information not just from licensees, but also from agents who are working within the industry. I think it's important to get that perspective for this issue. And then the other thing, so the comment that I wanted to make is sort of the way that I've conceptualized that the payment issue. So it might lend to an overall understanding. I thought about it in the same way that attorneys are licensed by the bar. We have to do our regular renewals, our regular registrations. And that's something that, for me being a member of the bar, I hold it, I own it. No matter where I go, I can still say, this is me, I have this certification. But a perk of certain employees or employers is the fact that they will cover that charge. It happens for all government employees. It happens for some other private firms as well. But the way that I was thinking was just having something more analogous to that, where an agent still holds on to that registration no matter where they go. They may foot the bill, but as a perk to employment at certain employers, there's an ability for it to be covered by them. So that was the overall, the thinking that I've added to it. And that's the way that I sort of think this through. But I hear what you're saying as well about leaving it open to some other considerations. I just want to make sure that as we have the conversation around agent registration, we also talk about empowering agents and making sure that they're able to continue in this workforce in the industry that's more seamless.
I couldn't agree with you more. And I think that was getting to the latter half of the conversation where that person who gets laid off or faces a closure, their ME, we don't want to lose them from the industry. They've invested too much of their own time and hard work, and probably if their passion's in the industry, how do we help them quickly transition? So I think the points you're bringing up, Commissioner, kind of all fold into that focus of the agent registration piece on the employee and how we allow them to be successful in this industry. Any other thoughts, comments, questions? Okay. All right. All right. We will move on to the next topic. Complaint resolution and, Commissioner, go ahead.
Should we have a listening session? To Commissioner Concepcion's point, where we want feedback from licensees and agents.
I'm certainly open to that. I think what would help us is to kind of give a document or something with some parameters around where we're thinking. I don't want to pass over, the notion or the idea of the temporary agent registration piece either, and get some industry feedback on that. So happy to do it, but I want to do it after we have a chance to kind of pull some ideas together for them to offer us some reaction to. So, okay.
I would just point out as well, in some instances where we don't have a lot of feedback, I think listening sessions are probably prioritized more. I think there's a lot as well that has gone to the legislature on agent registration as well. I think we have a lot to pull on. And then just to close that out as well, the point that Commissioner Roy made earlier for our government affairs team, there should be some additional sort of comparisons to other states available as well for that discussion. So I think if we put that together and feel that a listening session is needed, to revisit that at the time.
Thank you, Commissioner. All right. We'll move to the next slide. We'll bring up the topic of the complaint resolution administrator. Let me ask you, timing wise, how long do you think you need for this presentation?
More than 6 minutes, if you are if you are steadfast on your 12:30.
All right, let's do this. We'll break a little bit earlier for lunch. We'll be back at 1 o'clock. I know it's not only lunch, but it's some other topics that I know commissioners need to just connect with staff offline about. So we'll be in recess till 1 o'clock. Commissioner Concepcion, you back with us?
Fighting the mute button. Yes, I am here. Hi, everyone.
Okay. We are reconvening. Thanks, everyone. We will move on to the item that we were considering right before we jumped off for lunch. This is the job description of the complaint resolution administrator in a FY 2025-2026 budgetary impact discussion. So this is for our ED, our CPO, and our CFAO, but I can start off with the ED.
Thank you very much, Mr. Acting Chair. We're going to go through a few slides. We're going to indicate where the Executive Director, the Chief People Officer, and the Chief Finance and Accounting Officer will highlight some specifics, but obviously we're all available as well for questions and discussion as we move forward. And the genesis, the creation of this position, I'm just going to go actually through some high-level notes that were originally presented to the commissioners on March 13th, 2025, as it relates to what was deemed the tip line conversation. Obviously, there's a little bit more to it that we'll get into as well, but that was the discussion for March 13th. So the complaints process was highlighted in that presentation, which is 500, 300, in a time and manner determined by the commission. A dedicated telephone number, email address, or other means shall be provided for members of the public or consumers to notify the commission of complaints regarding marijuana establishments, marijuana establishment agents, or host communities. Obviously, some of these things have changed, especially in light of Chapter 180, where HCAs are now included. So, you know, this is part of the process that has led us in this direction. Additionally, within that, as within the regulation, is the commission may, at its discretion, investigate or decline to investigate any complaint or refer a complaint to another law enforcement or regulatory authority. So that's sort of what we're driving at, and this position has come out of that conversation. A few things I want to highlight within that presentation from March is that we have existing SOPs for handling calls coming in for external stakeholders, and those SOPs are all essentially updated and cover what we're doing on a day-to-day basis currently. One of the conversations that we're having, though, is that there is no single overall SOP across the commission for this. So that would be part of the process that would be coupled with the job description that we'll get through in a second. At that time, in the presentation on the tip line in March, there was also some data that we shared with the commissioners on sort of the scale and scope of what we're talking about. And so just to kind of get, before we get into this discussion, just highlight as well, the job description is included in the packet that's available online. The CPO will handle and go through that process and answer any questions. But there is additional SOP at least in terms of high level or multiple SOPs that will be part of the process prior to testing a new complaint process, and then ultimately looking to launch. Included in that as well is web platforms, web forms online, et cetera. So all of those were presented in March, and happy to get into it today, but the focus of our discussion today is really on the complaint resolution administrator, which was developed, which the Chief People Officer will provide some background on in terms of how that came about.
CPO, you're on.
Thank you, Paul. Good afternoon, Commissioners, ED, everyone. So I think this conversation started for me when I arrived at the commission back in August of 2023, I believe. So I'm going on 2 years. And when I came on board, there was a plan or some discussions, dialogue around a tip line. And so I believe at that time, Commissioner Roy had, been responding to some of our constituents who were talking about, or our licensees, or, people in the community in general. And Commissioner Roy can give us more information about that if my understanding is not exactly correct. But wanting to know of a way for them to provide feedback to us, in terms of complaints, if, something came to their attention, and it was a violation of any of our rules and regulations, that we had a way of making sure that we can field those complaints and respond to them. That was my understanding when I first came on board, few days into the job. And so subsequent to that, we started having more discussion around that. We were getting more feedback from our communities. And so we started a strategy group to have some discussions internally around how we were going to accomplish this. And that sort of led us to where we are today. We took a look at what position we could put in place to accommodate this particular task that came before the commission. We took a look at, where the position would live, and had those discussions. And so we came up with a job description. And it is a highly comprehensive job description, and I think that was included in your packet. So you should have had hopefully some opportunity or an opportunity to review that. It's pretty extensive. We came up with a job description internally. This was a collaborative effort with the CFAO, myself, the ED, and the CTIO. I always want to say CITO, but CTIO. And we came up with a job description that we thought reasonably represented the position that we were trying to implement. And we talked about the reporting structure. We talked about that this position would initially sit within the I&E department. It would report to the director of investigations, and then part of the discussion, or one of the biggest components of the discussion, was what would this position look like? How would this position, field those complaints? And we talked a little bit about maybe modeling this position off of the hearing officer's position. So there would be some sort of autonomy, especially internally, autonomy in fielding the complaints, disseminating the complaints to the departments where they needed to go, working internally with other partners to make sure that we are responding appropriately to complaints and information when they come in. And the other big component of this was that we wanted the position to be filled by someone who had a broader view and a broader understanding of the commission, because this position really, this individual we hire really needs to have that understanding, have that knowledge of the commission, have that knowledge of the regulations, our operations, and now it's going to be our response system. So we also talked about maybe this may be an internal promotional opportunity, or it may be posted both externally and internally, so we find the right individual to fill this role. Having that, and it's on your screen, I sort of talked around that, needs to possess a holistic understanding of the organization to ensure that we have a positive end user experience, and especially for external stakeholders. And key attributes, obviously, we need someone who is going to be highly skilled in customer service and is able to maintain the confidentiality of the role and the information that's going to be flowing through the complaint resolution administrator.
Thank you to the CPO, and obviously, again, we can come back to any of these items as we progress through. I'll just cover as well, one of the reasons for the reporting structure within I&E, where we continue to look for, probably as we look across the whole organization for opportunities for efficiencies, is that this position being the single point of contact, we don't want to have a single point of failure. And so within that, we have much more ability to support that role within I&E as we're currently constituted. But we'll continue, myself, the CPO, the CIO, CIE, and others will need to continue to look at the proper reporting structure over time. But certainly initially, this is intended to avoid a single point of failure here. Make sure that there's backup. This person needs to take PTO. There's a variety of different reasons that they need backup. So I think that's well written in there, and I appreciate sort of all the work that went into that by the CPO and others. In terms of organizational benefits, before we move on, centralizing the external calls is difficult to determine exactly how much of an efficiency we may be able to find through the creation of this position and changing of this process. But I think certainly we've viewed a few different ways that this could take some things off plates of current employees across the organization. We have 20 points of entry. That was part of the presentation from March on our current status quo external calls coming into the organization. So through that, we'll be able to capture certain data, how many calls are coming into the organization across all of those entry points, now through a central entry point that actually are getting routed to, let's say, MDAR or other agencies, et cetera. And it will allow us to continue to, in a bit of an iterative process, continue to improve. And then additionally, one of the things that I think people should be aware of, and this is actually a conversation I had with an external stakeholder recently, was in a lot of instances where people let me know that they feel like, our I&E folks are pinpointing something that they don't feel was pinpointed from another business. To me, I think we should all be aware that by having a centralized tip line, we're going to have more tips. And a lot of instances, people should understand that when we follow up on a tip and somebody says, well, I'm doing this the same way that business over there is doing it, that may cascade and there may be those, but that is part of the investigatory process and there's not a problem with that. That's actually how all of these regulatory bodies work. So there's a few things to consider here. One is that this may generate fines and actually pay for itself over time, though, as we discussed earlier, none of those fines currently go to the commission. Those all go to the MRF. But it is something that we should all consider. That is something that we may see as additional actions that come out of this regulatory body. And that is if people are looking for just greater efficiency through the organization, I think that's absolutely a benefit. But people should consider as well that most likely there may be additional tips that lead to actual action. And so that is part of this process and an intended part of the process. We can move to the next slide.
Chair, may I?
Or, sir, CPO.
I just wanted to just go back a little bit. So this position is not intended to be an internal complaint line or process, right? However, we do recognize that we may get complaints from employees that flow through there. So just wanted you to know that this is not what it's intended for. And any complaints that come through, the complaint resolution administrator would flow directly to HR.
Right. And that is written in the job description. So if there's any questions on that, we can certainly get back to it. And again, if there were a complaint that came in externally related to somebody in staff, the job description additionally would route that to HR. I don't know if we have a frozen screen, so let me a second here. Oh, there we go. Okay. And so this is really, not reinventing the wheel here. I just want to put it in kind of a visual. This is mirroring a organizational chart that's online to indicate that a complaint resolution administrator to the CPO, the point that the CPO just made, this position really needs to have a very good understanding of the entire organization to know where to be routing referring calls, following up with, supporting those departments as well in ensuring that we are resolving the complaint, right? Resolution being in the title here. So just wanted to really give a sense that part of this process is knowing where to refer, and then also part of this is tracking the resolution of something that's coming in, whether that's getting reported back out to the individual who contacted us or just for our own internal records. Before I move on.
I just have a question on this chart. So the position is nested under I&E.
Yes.
But it's not triaged through I&E, so it's triaging it directly to where it needs to go.
Right. So not every call, like if a call that comes in that is not for I&E, the individual doesn't have to go through I&E to route the call, right? But from a support for the individual as an employee perspective, from a reporting structure perspective, it's within I&E, right? But there are instances where they're referring calls outside of I&E. We go to the next slide. This first area is for the Chief Financial Officer and Accounting Officer.
I do, I have a lot, but I'll wait.
Okay. CFO, thanks.
As we stand right now, our projected FY '26 budget is 19.8 million. We're looking at $130,000 reduction from our current year budget. As it stands now, we have 153 budgeted positions in the current year. Right now, there are 16 vacancies in those positions. So we have those positions that are in different stages of hiring, from interviewing, beginning process where they're just reviewing resumes, and some are ready to be hired from those 16 positions. Right now, we're looking at about a $1 million shortfall in our budget compared to the current year. And that's prior to adding this position. In order to make up the difference for that $1 million, we will be looking at some attrition savings and delayed hiring or freezing some positions that are currently within our budget. We've looked at trying to fill those positions maybe on an as needed basis. So we will go forward looking at that way to make up that budget shortfall.
And so I think within that, one of the points I want to make leading into the recommendations here is that we do feel that it makes sense, in reviewing this with all the departments, working with the CFAO, the CPO, and myself, that we move forward with this position. Some of the conversations that we had earlier about, the operational efficiencies that this position represents for the organization. But it should be stated where we are right now in FY '26. Without this position, we were already having a difficult outlook. And so the $1 million projected shortfall obviously is based on numbers that the CFAO has right now. Those things will change should we have additional vacancies. But as of right now, we do feel like it's best to move forward with this position, evaluate it, which I'll talk about in a second. But it should be put in that larger context. And so the recommendations here are listed in 3 areas, and obviously with commissioner discussions, we can talk about all 3 of these areas, but posting the job description as presented, my recommendation would be the internal posting because of the need to have this person sort of have a solid understanding throughout the organization. Though an external posting, I'm bringing in, a skill set is also viable. The pay range starting at about $75,000, which is indicated in the document. And there's a range, as I said, that's where it starts. The second recommendation here is to evaluate the following elements in the first 90 and 80 days, should obviously the position be posted and filled, to develop the policy and SOPs for this position and then review them with all departments during this period, and review the impact to workload, not just for this position, but for the other departments currently taking on a number of calls that will otherwise now be routed through a new position. And the third one was communicated out to staff and commissioners. I honestly can't remember if it was last week or this week, regarding instituting a hiring freeze. We saw the same thing out of the executive office, the governor's press release announcement. Given where we are right now for the FY '26 budget, we are looking at needing to maintain a level of service and not being able to continue with just adding this position specifically as well. The complaint resolution administrator, this would not be able to be added on top of the positions that we were currently in the midst of moving forward with. So I think within that, I would say that it will not impact the current recruitments that have been ongoing that are obviously pivotal for the organization, and a hiring freeze can be overridden by the executive director in almost identical language to that one might have found in the press release from the governor's office. So critical positions like the director of testing that have been in process but are not currently set to start will continue on and be filled. So this is really a look ahead. And I think what I want people to understand is that we may lose folks for whatever reason. We've seen a number of individuals move on to, promotional opportunities at other state organizations. It is going to be felt in FY '26 if we have to live within the current projected $19.88 million budget. A hiring freeze will come into play, at some point with not being able to backfill positions. So just want to put that into context of this. Again, it does not stop the recommendation. because of the organizational efficiencies that we feel that this position can provide. But it is a serious concern at this time. And so that's the whole presentation. Again, the CPO, CFAO, or myself on any of these particular areas are happy to answer questions.
Thank you, ED, CPO, CFAO. I will open it up for questions. Go ahead, Commissioner Wright.
Thank you, Acting Chair. Thank you, CPO and ED. And I'm really pleased to see this come to fruition since the unfortunate death of Lorna. It really exacerbated why we need to have this. And since then, many of us receive complaints, tips, if you will, on a regular basis. So to go from 20 touch points to 1 is great. Hopefully it'll free up bandwidth for other departments if it's through this 1 point of contact. Also, I'm glad to see that you're recommending it to be an internal opportunity, because as CPO said, this person has to be familiar with our regulations, our policy, the industry, the departments. So I think it's an excellent internal opportunity. I guess I don't understand. Are you saying we're going to review it, vote on it, but we're not sure if we can move forward? Like, I guess I'm not fully understanding what you're saying.
I'm saying that we're posting this position within projected budget shortfall of our current calendar. And so, I think ultimately the answer is that if we didn't post this position, we most likely would still be in a hiring freeze scenario. I think posting this position, what I want folks to understand is that if we were to lose folks as we go into FY26 and we are unable to be posting backfilling positions, that this is just another part of that component of we may not have additional capacity to backfill positions in FY26 in our current financial projection. So this is part of that discussion. Again, whereas this has the opportunity, I think, as you just mentioned, to take things off of current employees' plates, centralize it, potentially find efficiencies. I think it's worth going forward with, but I just want that to be in the context of the discussion.
Okay, if I may.
Mhm.
Okay, you mentioned testing the platform. When is that anticipated for, like the web forms and everything? And maybe this is a Paul question, but.
And I think we do have room for Paul over the CTIO over by the CPO and the CFAO.
Let's stop this baseball injury.
I think it was generally within that presentation in March about sort of where the IT seems to be ready to go. And this was kind of our next step before we regrouped on go live. But I don't know if you want to add anything from the CTIO perspective.
Sure. The form is actually with legal right now. I'm just getting review on the language on the disclosure of the part of the form. So technology wise, it's done. It just needs to be tested.
Okay.
We still need to work on the back end on the reporting side of things and the tracking within the Microsoft Dynamics, but that is starting. That process has started as well within our development team.
Thank you. Okay.
Keep going.
Okay.
Go ahead.
So we just do a couple of ministerial edits on this job description. I found a couple of formatting issues. I don't know if you want to look at that.
Sure, I would want to approve it, have it approved with
Subject
allowance for ministerial
edits. Yeah, so I just want to bring them to your attention.
So go ahead.
So the first, where it says core responsibilities, the last bullet, it engages the legal team in consultation with the DOI on those matters that may require legal review. And there's a period, but then there's a continuation of a sentence in the next block.
Sorry, I'm seeing the last.
No, I'm in the board book, so I don't know if your iteration is different than mine.
Page 126 of the board book.
Yeah.
I'm sorry, page 126, you said?
In the board book, yeah.
I'm on the publicly available book. Okay, yeah, if you want to just highlight any of them and we'll take notes and then we can go through them with you before we have the position.
Okay, yeah, there's just a couple of ministerial edits.
Sure.
So, and the other question I had was around the hiring freeze. Is many of us get inquiries when job opportunities are posted, whether it's an investigator or And I think it would be helpful, like the governor did, if you could issue a press release saying that we do have a hiring freeze and subject to further review. We will, because we do, I know I do get folks who would love to come work here and send resumes. And I just think it would be helpful to the public to know that.
I believe there's a draft of that, so
Oh,
we'll absolutely follow up on that.
thank
I
you.
believe Neil was on it, but we'll follow up on that.
Yes, thank you.
Commissioner Camargo? Go ahead.
Yeah, I think you've asked a lot of the questions. I think my process, the kind of operation curiosity is just, obviously this is gonna have to be worked through how this actually works. Because we get tons of complaints, all of us since day one, from the industry, from employees, from, our friends in municipality. So this will be interesting. And I'm just thinking about like, okay, so in the future, do commissioners just press forward, to this person, right? So not just I guess trying to figure out like, and again, this is for later, but it's a tip line. It's also a complaint line. It's going to end up being almost everything, position. So exciting. I think it's great. And I was wondering about internal, external. I think internal for this will make sense if it's the right person with the right knowledge and the right confidentiality, because a lot of the stuff that's going to come into this line or to this person will be very confidential. So if it's, I just hope that's also taken into consideration. But yeah, makes sense. Thank you.
Thank you, Commissioner. Yeah, I just have a couple of questions and kind of gone over some of these, I think, before. But I want to go back to just for a little more clarity, a little more detail. This could be to CFAO, CPO, or ED. Other than director of testing, how many other positions do we have out in the final hiring stage, and what are they?
Okay, we'll take that one. Okay, can you repeat the question?
Sure.
Please.
We talked about, we have a number of current positions in final hiring stages, pointing to the example of director of testing, which I think we're all on board, we still need. But just give me a sense of what the other positions are that are that far along. Let me spit it out that way.
So we do have a list, and I'll give you a few of them, and you probably can guess what the rest of them are. Right now we have the CCO role that's on freeze right now. That's the Chief Communication Officer role. That's on freeze. The Operations Manager role is also on freeze. We have a possible, because we're looking at an internal promotional opportunity. And if that comes to fruition, then that backfill, we probably would not be moving forward with in terms of posting and hiring. And that would be a gap analyst role. And there are two of them like that. The other one is a project coordinator. The project coordinator is going to be moving over to IT. So that's an internal transfer. And in that respect, we would not be backfilling that position. So that backfill would be on freeze.
But for the positions, if the question was the positions that are going to continue to move ahead with hiring, so in those examples, the director of testing is in the interview phase. We have positions as well. There was a constituent services associate that was recently posted. So the positions that have been posted from all the way from being posted recently to being in the interview stages are the positions that will continue on. And it's positions that come thereafter, or the ones that are currently open, as the CPO just mentioned, that we anticipate being caught up in the freeze.
Sorry about that. I was giving you the whole.
Yeah, no.
The big picture, because it's going to come back to, which ones are freezing, which ones are opening. So
no, I appreciate the bigger, broader view. So you helped answer my question. You helped answer my question. Give me a little sense, and again, this is a question either for the CPO or the ED. Help me understand the concept of the autonomy of the individual. Let me break that down a little bit.
Yeah,
Oops, go ahead.
from my perspective,
Mhm.
it's about maintaining that confidentiality within that particular role and also to avoid conflict. Because there could be a possibility that a conflict may arise. And so we want to take out, any of the guesswork around, is this a conflict? Is it not a conflict? To have that certain degree of autonomy and confidentiality so that we can address these issues when they come in. So that's the primary reason why we need some autonomy in that role.
Okay.
So if I just could expand on that, just to go back to my other point, I think the confidentiality has been kind of the reason the CPO and those who have been part of this process, it was difficult to come to the right conclusion here. I think the problem would be ideally it could almost operate similar to the hearing officer, right, that we heard earlier. My concern, if we were to go that route out of the gate, is we are setting up a single point of failure. So by having it within I&E right now, we have a variety of individuals who can cover should there need to be backup. In the long run, as the CPO and I have discussed, ideally it could be separated for being sort of independent, similar to the hearing officer, but we just don't have the proper support if we went with that method out of the gate right now. So as you read in the job description, as the CPO mentioned in the development of the job description, should there be something that's HR related, that is part of the process of this person. It's not bringing it up through the chain of their current reporting structure. It's going directly to HR. So a lot of the position is designed to avoid the conflict, understanding that, to have support for it, it needs to sit within an existing department. And we feel like we found the right initial phase for that. Ideally, in the long run, we would have the resources to have a similar independence to the public hearing office.
Okay. I appreciate that. Two more questions, and I see you, Commissioner Concepcion. We talked about all the points of entry that currently exist coming into the commission. Sounds like, I think the ED from your presentation, some look at the analysis of what all those avenues into the commission kind of deal with. Is it your expectation with this position that we can maybe go back and kind of narrow down those 20 to a handful, or is that further down the line after appointment, after hiring, and taking the opportunity data-wise to look at what kind of comes through each portal?
So it is about centralizing. And so there are instances, constituent services working directly with medical patients and practitioners is an example of probably one that we don't want to feel like it has to route through this centralized process. But for the most part, otherwise, we are looking for the majority of external calls to be going through the central processing. So I'm not sure. The CTIO seems like he might have a thought on that question.
One of the things is one of the couple of entry points are multiple email addresses. So routing having the single email address, same thing with the web form. So there'll always be several entry points because phone calls, emails, potentially written letters will still come in, but still now having a funnel for them to go through. So the goal is from the start to have this consolidation.
Okay. And one last question. And I think Commissioner Roy, correct me if I'm wrong, you've alluded to some potential legislative pieces that are out there that could affect the impact of the word confidentiality of information. Again, I voice my concern. I'm in agreement. We need this position. Great way to funnel, complaints and things like that. Again, I am worried about complaints that people just call into. Don't leave us any information. Don't leave anyway. We do hear, well, I called and complained to the CCC. I never heard word back. Sometimes maybe that individual isn't leaving their information, or maybe there's nothing to follow up on, but obviously that getting back to the complainant person themselves, so we're not chasing, our new complaint resolution administrator is not just chasing some follies here and there. Is that kind of all tied together? Are we looking for some of these legislative pieces to happen at the same time, or they don't need to happen for us to move ahead with this? They're just things that could come along that would impact work later. Yes.
Yeah, thank you.
Ken, before you go, Commissioner Stebbins, I don't understand what you're talking about in terms of the legislative piece.
Well,
Want me to elaborate on it?
what's that?
Want me to elaborate,
Yeah, you can. I know Commissioner Roy has brought up
Yeah.
confidentiality pieces
Yeah.
to this work. At the same time, I voiced in the past that, I agree we need this position for all the reasons, Commissioner Roy has pointed out, all the points of access. It's great to have it. I will kind of go to a centralized point.
Right.
I am worried about our person being set up to go chase unfounded allegations, complaints, and things like that. Some of that relates to confidentiality of information, which I don't think we have right now the provisions to protect. But also the fact we do hear from folks that say, I called in and complained about a billboard or something like that, and they just got follow up. And that was something that we heard at the Ways and Means hearing. So it's a little bit outside of this position in our decision, but I know there's some kind of external legislative pieces that might impact this
Can I
or the work going forward.
Yeah.
Sorry.
I appreciate you saying that and explaining, because I wasn't understanding. But I think one of the things that I also was thinking about was who's going to, I know you guys created a job description and this is going to sit under I&E. I'm curious if I&E or if the Chief Jones was part of the creation of this role, since it's going to sit in I&E, and then it's going to have to, this person's going to, have their hand in every single cookie jar in every single department. So I'm just curious of, when it comes to that too, is how is, the development of this, does it make sense to I&E as well? But yeah, thank you for that.
Just to answer that question, the CPO and the CIE worked a lot on this together. And I think that, I think in a number of instances, I don't want to paint the picture that everything's going to sit with this position. Should this position need to refer something to GC?
Yeah.
In a lot of instances, they're the administrator of something that came into the organization. And I also want to sort of touch on something that the acting chair said, which was about a specific example given to us at the Joint Ways Means, which was somebody called in a complaint about a billboard. The person didn't get a call back. And then at the end of the story, it was shared that the billboard came down. So I think in certain instances too, within the development of the SOPs and sort of the way that we're looking at this, if calls are coming in that can't be substantiated or we don't have enough information to go on, the complaint resolution administrator is going to reference the fact that the call was made, that why there was nothing to go on, right? And if it was something that needed to be referred to the general counsel, that the fact that it was referred to general counsel and not necessarily have any information that doesn't need to go back to the CRA. So there's a lot of things that go within, obviously the SOP. I think the job description does a great job of kind of explaining that all of that is expected of this individual to be able to have a control over, but that the SOPs as well would kind of get into some of the specifics.
Okay. Commissioner Concepcion, hang on just a second. I want to let Commissioner Roy, I think, answer my question, then I'll go to you.
Yeah, thank you, Acting Chair. Thank you, Commissioner Camargo. So we were very mindful in discussions on what we named this. Originally I had said whistleblower, but that comes with its own set of obligations, and one of them being anonymity. So where other oversight agencies and other government agencies can convey or bestow whistleblower protection, we don't have that ability at the commission. So we were mindful to call it a tip line because we didn't want anyone to have a false sense of anonymity where, and because if something's under investigation, then we're not obligated to release that for a public records request. But once the purpose has expired, then we are obligated to release that. So right now, legislation. One of them I provided written testimony in favor of, Bill S-88, which would have a whistleblower, anonymous whistleblower, establish a whistleblower protection program for individuals reporting violations. So that would have to be a carve out given to us by the legislature. We can't automatically do that.
Right.
So, but having said that, what do we do to streamline the process? One touch point, make sure it's triaged appropriately, make sure workers are heard, patients are heard, consumers are heard. And so the need for it, and it's in our regulation, you know, we have to do it. So sticking to our regulations and being compliant with them and hearing from stakeholders, and you always say we're complaint box A, right? And we also have to be mindful, we're adjudicators, we're not just regulators, and we have to keep our independence and objectivity. So I think that'll help in that area as well. So we were very mindful on how, right, Paul, you and I had conversations around this. What are we gonna name this? So hopefully that answered your question. As of today, we don't have a carve out where we can bestow some sort of whistleblower protection. It's not there yet.
And that's fair. And you've brought that up in the past as you've been working on this. So I appreciate that. Commissioner Concepcion, go ahead.
Thank you. And I don't want to get ahead of anyone. My question is regarding the overall hiring freeze. I know you mentioned, this is to our executive director, that depending on how far along people are in the process, that sort of determines which positions are frozen, which aren't. But it sounds like there's still positions that we have currently posted that will be impacted by the freeze. My question was regarding whether or not those positions will be removed from our from their postings, whether people can anticipate their information being held by us until there's any changes in the freeze, or just so overall, what is the plan? What's the plan for those jobs that are posted but are no longer moving forward because of the hiring freeze?
So I think if I may have misstated that if I said that. I think if a position is currently posted, it is still moving forward. I think the point that the CPO accurately made was that in certain instances, by filling positions that are approaching being filled, that it is, if those are internal or lateral moves within the organization, that the freeze may impact backfilling the position from which those individuals are coming from. Does that clarify?
I believe so. So anyone who has or is in the process of applying to a currently posted job that we stated is available, they will not be impacted by the freeze.
The positions that are currently posted will be moving forward for to be filled. Yes.
Okay. Thank you.
Thank you, Commissioner. Do you have another question? Okay. Any other?
May I make a follow-up comment?
Sure, CPO, go right ahead.
So one of the things that we are considering is when we're looking at freezing the backfill positions, as we move throughout the budget year, if there are funds that are going to be freed up and we can hire those positions, then we will go ahead and do that. So so it's just a matter of having the funding to hire these positions. And as we have attrition, you know, that also can help us to make a decision what positions will be hired. And that decision will be made by the AD.
Okay. Any other questions or comments? This is up for a vote and consideration. I would seek a motion. Oh, Commissioner Roy, go ahead.
But Debbie, you said that you're moving one project manager to IT. From what department are they moving to IT?
So we're moving a project coordinator.
Oh,
Project coordinator, not a project manager, project coordinator. We're moving over to IT.
from what,
It's an intern.
from what department to IT?
It's
official, or we're giving?
It's in the works.
Yes.
There's an offer in the works. That's why I can't say names or anything like.
No, I don't want to say names. I just didn't know where we're
Yeah.
moving resources from what department to what.
So the project coordinators right now, I believe that particular one lives in IND.
Okay, thank you.
Want someone to find out they got a job.
Live, yeah, no, live and in real time.
I'm really sensitive to that.
Live information.
I know, but we start talking and then we end up putting you in a predicament.
Or the employee.
You know, and again, just before I seek a motion on this, you know, obviously the commission does approve every new job position and the related job description. But I think through this discussion today, I think it's more not about just necessarily the details of the job posting itself, but questions for commissioners or answers for commissioners to have of obviously budgetary impact. And we talked about budgetary concerns going forward a lot, but also where it fits in the structure, where it fits in within the responsibilities of the commission. So for anybody watching us, again, job description, you know, we don't get too much into the details in terms of some of the background requirements. Obviously, we rely on our team. I think for us, when it comes to these types of decisions, it's all kind of figuring out where people are going to sit in the structure and how the structure is going to continue, how the organization is going to continue to work. That said, I would seek a motion to approve the job description for the complaint resolution administrator. Do I have such a motion, Commissioner Roy?
Gladly, so moved.
Okay. Do I have a second, Commissioner Camargo?
Second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Camargo? Commissioner Concepcion?
Aye.
Commissioner Roy?
Before I say, I just want to thank everybody involved. I believe it was CPO, CTIO, I&E, probably legal, everybody involved that helped get this job description, ED off the ground for us to vote on it today. So thank you all. Aye.
Okay, and Commissioner Stebbins votes aye as well. 4 in favor, none opposed. All right, we'll move on next to the legal intervention update, and I will turn to our GC.
Good afternoon. Thank you, Acting Chair. So the last time we talked about intervention a few months ago, there was a request to provide an update when further information became available, and I'm happy to be able to tell you that there is an update. So just to go back a step here, as you'll recall, there's a lawsuit pending in Middlesex Superior Court involving 3 licensees in the town of Great Barrington who have sued the town and are seeking relief in connection with their HCA and obligations regarding community impact fees. That lawsuit is the one that we were seeking to intervene in. Last time we spoke, I'd indicated to you that we were working with the AG's office on getting approval to file intervention paperwork. And I'm now happy to be able to tell you that we have been approved to do that by the AG's office. We did go back and forth and landed on a resolution that was satisfactory to all. And so we have now, as of today, submitted our paperwork to the court. And I'm actually looking at my email to see if everything has been accepted for filing. But so this is very current information. We are filing to intervene in the case. We have filed a motion and supporting paperwork to that effect. The parties here, just so you're aware, the plaintiffs have assented to our motion. The town, represented by KP Law, has objected to our motion. So there was a process to go through to it's called Superior Court Rule 9A, to allow for their opposition to be received before the filing is made to the court. That has been completed. We have now filed. In our complaint, we are seeking 1 count of declaratory relief under Chapter 231A. Essentially a declaration from the court that the commission has the authority and obligation to review each and every HCA annually, upon license application and thereafter upon renewal. So annually upon renewal. And to further rule that the town is required to cooperate with the plaintiffs in submitting compliant HCA's for the commission's review and approval. So that is the gravamen of our complaint and the relief that we'd be seeking in this case, should we be permitted to intervene. So in terms of next steps, like I said, the motion has just been filed. The court will now review it, and there's really no timeline on how long that'll take. But we will get a decision from the judge on whether we've been permitted to intervene, and then we will take appropriate next steps after that. The next step in the case is there's a hearing scheduled on June 9th on pre-existing motions that the parties had filed. And again, depending on the timing of when our motion is acted upon, we may or may not have a role in that hearing. So that's the quick update here. I'm happy to answer any questions that you have. I want to thank the AG's office for working with us and getting us to the point where we are right now. And very glad that we're in this spot and looking forward to receiving the ruling from the judge.
Thank you, GC. Any questions for GC? Commissioner Wright, go ahead.
And the plaintiffs are seeking what relief?
Plaintiffs are seeking a number of different types of relief, but essentially they are, like us, they are seeking an order from the court requiring the town to cooperate in negotiating an HCA. And in addition to that, they are looking for a whole bunch of types of relief involving community impact fees that have been collected previously that they contend were collected unlawfully.
We're not opining on that aspect.
Correct.
We're just opining on within our authority to review, certify, approve upon application and renewal.
That is correct.
Okay.
Yes.
Any questions, Commissioner? Okay. Commissioner Concepcion, any questions for the GC?
No.
Thank you. Thanks for the good work. I know this has been a long process, but also express my thanks to the Attorney General's office for their support of allowing us to intervene in this case. Next item up is our draft guidance on positive impact plans, and we are joined by our licensing manager, Suko Defoe. Hi, Suko. How are you?
Hi, Acting Chair. I'm good. Thank you.
All right.
So it's ready. So today we have before you the guidance on positive impact plans. It was already presented in a previous public meeting. During that meeting, the board had suggested 2 minor edits. So the first suggestion can be found on page 3. We added applicants and licensees may opt to publish their positive impact plan on their business website. And the second can be found on page 4, where we highlighted the Executive Office of Economic Development donations as a goal. And those were the only 2 suggestions we had from the board.
Suko, I'm sorry, you cut out for a minute on the additions you made to page 4.
Okay, so the addition on page 4 was to include a specific section for the EOED donations as a goal, and that was added. And those were the only 2 suggestions we had by the board.
Okay. In that link in the guidance, does that takes you right to the Social Equity Trust Fund page, but I don't know if you've checked it out to see if it goes directly to kind of their contribution page or how folks go about making contribution, or is that to the larger fund page overall? I guess I can do that.
I can check it again real quick if you give me 1 second. It takes it to the Cannabis Social Equity Trust Fund page.
Okay. Okay. Thank you, Suko. Appreciate that. Commissioner Roy, go ahead.
I'm requesting a 5-minute recess to confer with legal and the ED on something in this document?
Can I
Sure.
ask a question before we break?
Yes, go ahead. Go ahead,
Just Sugo,
Commissioner
if you can
Concepcion.
highlight, what was the other change you highlighted? You said the webpage inclusion, and what was the other?
The webpage inclusion and the donations for the EOED for the Social Equity Trust Fund.
Thank you.
Good. We'll take a 5-minute break. We'll come back at 2:15. A little more than a 5-minute break.
We are unmuted. That's a
Okay.
great place to land.
We're reconvening a little bit after 2:15. Let me just make sure. There's Suko. She's still with us. Commissioner Concepcion, are you with us? There you go. Thank you, Commissioner. All right, we took a short recess. Commissioner Roy, you wanted to discuss with legal something within the guidance for positive impact plans?
I did. Thank you, Chair, and I'll turn it over to legal.
Thank you, Commissioner Wright. At this point, following our conversation, I'm going to recommend that we table this matter until the June meeting.
Okay.
The June meeting.
You can ask, sir.
Well, I guess we didn't discuss it, so I'm just curious.
There was some language that Commissioner Roy had identified as requiring some additional legal review.
Okay.
And I think we just want to make sure that we
Okay.
complete that before bringing this for.
Fair. Good to know. Thank you.
All right. Again, happy to table it until the June meeting. You know, we don't necessarily need a vote, but Commissioner, do you want to take a vote to table it?
Say vote on the.
And I would just put the date certain in the motion to table, so the June 12th meeting.
Yep. I'd move to, go ahead.
Are there, okay, because we're tabling it, we're not gonna have a discussion around it, but is that the only thing that is questionable right now? Do any other commissioners have? Any other questions or comments?
Go ahead, Jesse.
I can't speak for the commissioners' comments, but I think that the document does need a more full review,
Okay,
not just in that one particular
okay.
area.
I mean, obviously a lot of good work put into this. I think this was probably another outstanding task in Chapter 180 because we wanted to make sure that building into positive impact plans, the provision that we all agree upon, which is allowing people as part of the licensees, as part of their positive impact plans to make a donation to the Social Equity Trust Fund. But, you know, this,
That makes sense.
the plan has been around, so I'm happy to let legal take another.
No,
I know those additions were needed and required, so I'm
Yeah.
happy to have them in.
I'll just say, no, I'm happy and agree. It's just that we probably had a conversation about this months ago. So it's just a reminder to all of us to read,
Right.
edit, because if one of the commissioners found something today and that, somebody missed or is questionable, this has been kind of lingering for months now. So that's why I'm just, kind of, what did we miss? So I'm gonna go back and look at it myself too. So thank you.
All right, I'd seek a motion to table approval of the updated guidance on positive impact plans and bring it back for the agenda on June 12th. Do I have such a motion, Commissioner Camargo?
So moved.
Do I have a second, Commissioner Concepcion?
Second, I'm sorry, I have a question.
Sure, go right ahead.
Oh, are we going to be made aware of the concerns before that next public meeting?
Yes.
All right, second.
Motion been made and seconded. Any further comments or questions? Seeing none, I'll do a roll call vote. Commissioner Camargo?
Aye.
Commissioner Concepcion?
Aye.
Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 4 in favor, none opposed. We will table until we bring it back, table until our next regularly scheduled public meeting on June 12th.
Thank you, Commissioners and Acting Chair.
Thank you, Suko, for your time and work. All right, next we will move on to updated document, our guidance on equity programs, and invite Director Williams to join us. Can I ask you to slide down just a little bit? There's available space and we want to make sure you're on camera.
Hey, when you talk, yeah.
You want to turn it, go ahead. I think, if I'm not mistaken, but we'll let Director Williams walk us through this. These are needed changes as a result of changes, I believe, from Chapter 180 and updating our equity programming guidance. So Director Williams or ED, I don't know if you want to kick it off or I can go directly to the director. All right.
To advance the slide, I believe, but other than that, I believe Director Williams will give you a summary.
Good.
Good afternoon, Chair and Commissioners and Executive Director, GC. Thank you for having me this afternoon. So I bring back for your discussion and vote the guidance on the draft guidance on equity. The edit that was asked is information to be added with regards to the Cannabis Social Equity Trust Fund and a link to their webpage. And then there was some editing that needed to be done, just some formatting on this document. That is the feedback that I received from the document. So I open it to any further questions.
Thank you, Director. Obviously.
And that would be page 12, I'm sorry.
And I'd also clarify, I said that we should need to advance a slide. There is no slide, so you have it in your, so my apologies, that was my mistake.
Jump the gun. All right. Thank you. And again, as I read it, it's not just the updates around the Social Equity Trust Fund, but it's also about the new identification for folks to pursue to be identified as a social equity business as well.
Yes, that information existed in the original draft that was before the meeting in the last discussion.
Okay. Just going to take a minute to look for one more thing. I thought I had another question.
Sure.
Commissioner Roy, go ahead.
And thank you, Director Williams, and don't kill me, but I'm wondering, in light of the new Equity Work Career Hub.
What page would that be?
No,
It's
not on here.
Oh, okay.
That's the
We
question.
make
That's
that
not-
You
So
know,
a benefit.
yeah, because I think that's an incredible tool, and I don't know if at some point we should add this into the.
Definitely, that's something we could add in, I can add it in.
On the end.
It's something that we communicated when this draft was created that wasn't available.
Didn't exist, right?
And by the time you got this packet,
Yeah.
that also wasn't
Yeah.
something that was available. So
Yeah.
I can add it in the future. It doesn't officially launch till June. So
You can
when
add it.
it's actually, yes, so when it's actually, it's Equity Works Career Hub. Once that's officially launched, it would probably be more applicable to put in this document and just add that as a benefit.
Yeah.
But it will be publicly made available mid-June.
I saw that, yeah, but I think it's great.
Thank you.
Yeah, okay, awesome. So you can add it then.
I could definitely add it. I mean, if you approve for it to be added like now.
Language, and then
before
we
it-
say,
yeah.
or we can prove it and then say, add that to the motion language that you're gonna add that.
Yes, I can definitely do it.
Just a quick question, Director. I know we reference, trying to find it in the document. I know we talk and you reference in here, I think the provision under Chapter 55, which specifically lays out how we can help minority business enterprises, women-owned business enterprises, and veteran-owned business enterprises. Obviously, as the commission has continued its work, and we see on a number of occasions where licensees put into their diversity plans that they also want to help out disabled individuals with disability, business enterprises, and LGBTQ plus business enterprises. How, I understand what Chapter 55 says, but in looking at this document, where can we begin to fold those two other business enterprises and this this is a certificate, these two certifications are available through SDO. But what might be holding us up from including those, or what are your just thoughts on finding a way to include those two other certifications as well? Obviously, again, then those last two are not referenced in Chapter 55, but is there something we need to do going forward? Not that it necessarily impacts this document, but is there anything that we need to do going forward to make sure, possibly expand the opportunities for those two types of business certifications? Go ahead.
Thank you, Chair. So I guess it's a two-part question. This vehicle, or what this document is it represents the existing equity programs that we currently have and what those initiatives are. When we're talking about prioritizing the LGBTQ plus or veterans or those different buckets, equity includes everyone. But a lot of our programming is very specific for a specific reason, i.e. like the criteria to get into the social equity program. And so if that is a demographic or a community that needs to be prioritized, then that would need it to live in its own program. SDO prioritizes minority businesses, women-owned businesses, so it needs to have or be placed in an equitable category and then programming like set for that. But when we're talking about the community outreach and the things that the equity programming community outreach team does and the commission as a whole, we aim to make sure that even if it's not fit in the actual equity box that we are, pushing forward, that we are recognizing and reaching all different communities. When we go to Provincetown, we had different people from different businesses representing different communities and different backgrounds. So it is infused, but this particular vehicle is speaking to the equity programs and benefits that we currently have and who our mission was legislatively mandated to prioritize.
Okay. And I know we have actually a call coming up with the new appointed director of the SDO to see how we can continue to work and collaborate with that department. Obviously, they do a lot in terms of pre-screening people that want to get into the licensing process with that kind of initial designation. The other thing, not quite related to it is related to the equity program, but I would love for you to give us because Commissioner Camargo, on her second to last meeting, has echoed the same concern with us about the name of the ancillary track. And I know you've done a lot of homework and the team has done a lot of homework to just come up with a different name for the ancillary track. So I want to give you the opportunity to talk about the new name if you want to.
So the curriculum it's all based around the curriculum. It's also making sure that we're meeting everyone where they're at. The conversation around ancillary business, quite honestly, when I went to my first cannabis event here in Worcester at DCU, it was like a cannabis cup or something like that. And there was like a big sign and I'm like, what's ancillary? I don't even think I could pronounce it at first. And I am educated, right? I had to look at it and I'm like, and I really had to think and I had to Google it, but then I got it. Like the more that you utilize it and are in it, but if you're not, or you're just getting into it, or you're just not even familiar, and then what do those businesses really represent in the cannabis industry, right? How do they uphold businesses? How do they support our industry? And what they really are integrated business solutions. And so that is the name. And so as you see us carrying out our curriculum, we're still using the word so people can start associating with what it means with the idea that eventually it will be retired. So our ancillary businesses, we're just kind of quite frankly calling them what they are, and they're our industry integrated business solutions.
Congratulations, Commissioner Stebbins.
No, congratulations to you. Our gift to you on your last day.
Thanks.
Commissioner Roy.
Hey, and thank you for that. And if you think about it, when we go to CANRA or any of these, NECAN or any of these massive conferences, the bulk of the floor booths are these integrative business solutions. Like it's
using the new name.
Yeah. So yeah. All right. So thank you.
All right. All that said, just to give you a little platform to talk about the good work you and your department continue to do.
Can I just say,
Go ahead,
I know we're not-
Commissioner.
but it's been such a thing. And Commissioner Roy, I think you can appreciate this. I know you like marketing and branding and things like that. So this was a big situation because people didn't really understand what ancillary, services were or are, or even to pronounce it. And we got so much feedback from it for years now. So even switching his name is looking kind of, yeah. So
Right.
the little things make us
But
happy.
we don't want to confuse it with IBS, stomach upset. Oh.
Yeah, just killed it for him. Yeah,
Commissioner, I was wondering when someone was gonna, I was like, oh my goodness, maybe we'll just,
Don't use that.
no,
no acronym.
integrated business solutions.
Yeah.
But, I wanted to give Director Williams a chance to talk about that change to the program and to that track, because one of the things I've noticed when I first came on board was all of the people, when we open up the cohort, they flood to that entrepreneurial track. And we know there are a lot of people out there that
That's the.
are interested in this industry, have services that they can provide to this industry. But I think there was that disconnect, they don't want to touch the plant, they don't want to be licensed, they want to just take the business that they currently have and take advantage of, this new industry coming to Massachusetts. So,
It's a good
I
point.
thank you for that.
Thank
I
you.
think it's a good thing. And again, is we have that conversation with the SDO to get them, as they talk to all of the people that they license and register, to begin to get them to think about, talking to folks and making them start to think about what the opportunities are. All right. No other questions. I will seek a motion to approve the Commission's guidance on equity, subject to an addition on the Equity Works Career Hub. And I would say I delegate approval of that addition to both the director and the ED. I don't think it needs to come back to us. Honestly, we want to see where. Do I have such a motion, Commissioner Camargo?
So moved.
Do I have a second, Commissioner Concepcion? Or do you have a
Second.
question? I'm sorry.
No. Second.
Okay. Okay, motion been made and seconded. Any further comments, questions? Seeing none, I'll do a roll call vote. Commissioner Camargo?
Aye.
Commissioner Concepcion?
Aye.
Commissioner Roy?
Thank you.
And Commissioner Stebbins votes aye as well. 4 in favor and none opposed.
Thank you very much. I appreciate it. And I just want to say that if you saw the original document from our guidance on equity programs and how this has grown and it's evolved and the things that we're doing in the industry, this is really work to be proud of. So thank you very much.
Thank you, Director Williams. Appreciate that. All right. All right, next item we have up is commission election on a new secretary. As we all know, Commissioner Camargo has been serving as our secretary, I think, for the past 2 years, since 2024. With her departure, we need to nominate and appoint or elect a new secretary. I'm going to go first and make a nomination and see if it will be accepted, but I would like to nominate Commissioner Concepcion to be the commission's new secretary. Commissioner Concepcion, do you accept the nomination?
I have big shoes to fill between you, acting chair, and Commissioner Camargo. But yes, I do accept the nomination. Thank you.
Okay.
And Commissioner Roy too.
And Commissioner
Both of
Roy.
you have served on the
We've
field.
all
Oh,
had the
wow.
privilege.
I'm the last of the Mohegans, so I'm the last one. Okay. Yes, I accept.
No pressure. Great. Thank you. Thank you. All right, we have one nomination. Are there any other nominations? Quickly seeing none, I will move for the commission to elect Commissioner Concepcion as the commission's new secretary. Do I have such motion, Commissioner Camargo?
Can I just say something before we get there?
Of course you can.
We did acceptance speeches last time, Commissioner Roy and I, and now I'm doing a goodbye quick speech. But no, I just want to thank everybody that I work with as a secretary. It's the legal team in terms of preparing the minutes, looking at things, reading them, working with them to prepare stuff before the deadline. There's a lot of minutes. The stuff is very, very complicated to write up and to do and make sure that every single word matches, you know, at some point what we're talking about in these meetings. So I just want to thank the folks on the legal team, and I'll leave somebody out, but you know, Brendan and Rachel and folks who work on this stuff on the legal team. Thank you so much for your attention to detail when it comes to these minutes. As I read them all word for word and I ask a lot of questions. So thank you so much. Yeah, and Commissioner Concepcion, you're gonna have fun. This is a different role. So and you're an attorney, so you're gonna even enjoy this a lot more than me. And that would be. Did you want a motion or?
We have the motion. I believe Commissioner Roy seconded it.
Did you? I think you were asking me to.
Asking you to make the motion. Yes.
I threw us off by
Okay,
chance.
you did.
So moved.
Commissioner Roy, would you second?
Second.
Motion been made and seconded. We can do a roll call vote. Commissioner Camargo.
Aye.
Commissioner Concepcion.
Aye.
Commissioner Roy. And Commissioner Stebbins votes aye. 4 in favor, none opposed. Now we'll tell you that the job does come with parking here in Worcester. So,
Madam Secretary.
there you go. All right. Thank you
Amazing.
Commissioner. Thank you so much. Appreciate you stepping into the role.
Commissioner Stebbins and Ivania. I just want to.
And Ivania.
Thank you.
Okay. All right. That said, I think now we need to go back to discussion of the draft governance charter discussion. Again, we have been at the work on this draft governance charter for quite some time. It has extended out over a number of years, a number of sessions. It went through, in my opinion, a number of variations from a very high level to a very granular level, back to, I think, a very level-headed level. It has been a lot of our work. It has actually gone through several discussions in open public meeting. 5 of those dates last year, July 11th, August 14th, September 12th, September 27th, I think, was the last time we went through a thorough read line by line with commissioners. I think myself and Commissioner Camargo and Commissioner Roy, I believe at that 27th meeting, we went through a number of pins that we wanted to put in the document. I want to thank my colleagues, Commissioner Camargo and Commissioner Roy, who went back and worked with legal to work through and vet and assess all of those pins. I think I had one pin in the document that I went back and worked with legal on. We had discussion about the document again on December 4th at an open public meeting. At some point, and I know it was always at least, you know, my hope that we could have had work on this governance charter done as a way to help onboard a new executive director and kind of give them the guidelines and of their work and the responsibilities. Obviously, as we move through the executive director search and get towards the end of it, at least it was always, you know, my impression that it was a good thing for us to wait until the new ED came on board and had an opportunity to kind of have input into the document as well. I will say personally, as we were going through the ED search process, it was always encouraging to see a candidate who do his or her homework, but for our current ED to hear him at several points, I think during the interview process, talk about this document. And, you know, again, just speaks to the value of, you know, seeing a candidate for a position that, you know, does the homework ahead of time. So happy to get it to this point. Again, we all ask that the ED bring this document back to us for final approval, final resolution. And again, it's helpful to get the work on this done, and to get the work on this done for the goal of creating clarity for both commissioners and the ED and staff as to responsibilities, interactions, work of the commission, kind of speaking to things outside of the legislative statute, and offer some clarity, which was, again, kind of the goal of this work from its initiation back in 2023. Am I going back that far? Or 2022? But this has been a long process. It's been a helpful process. It's not been sometimes a smooth process, but we've gotten here. I do want to take the opportunity now to hand it over to the ED to have him walk through the work that he did on his end, some of the proposed changes that he has come up with, as well as changes that I believe he's had the opportunity to interact with commissioners on to get final input, and also just kind of relay to us kind of the background work he's done to share and kind of work this through with staff at the same time. So happy to turn it over to the ED to pick up the presentation.
Thank you very much. I can share. If we could go to the next slide. So first I'm going to go through high level where I am, sort of the process that I had gone through, and then I do want to get into the document. It is in the public board packet, which is online, and I'll go through a couple items. But so just really quickly, and I'm not sure if my slides made it in, so I'll go through them again, really high level, talking about the process. And if they catch up, we'll go from there. So the first thing I just want to mention, I believe the acting chair mentioned it as he introduced the topic as well. I had reviewed the last document that had been available in a public board packet at a previous public meeting of the commissioners. In my interview in October of 24, and actually I believe at the time Commissioner Roy, mentioned, and then this was part of an interview that I did as well with Talking Joints memo, I think, that, in terms of transparency of the process of the commissioners, that was made available through the public meeting process, through the board packet, and I was able as an external stakeholder to review that. I had thoughts because at the time I was finalizing the Town Manager Act in Holliston, which got finalized actually in October of 24 and signed by the governor in January 25. So it was something that was kind of at the top of my mind, and so it's been in my mind since before I started on March 3rd. It's also is in one of the short-term goals within the executive director goals that were approved previously by this group of commissioners since I started. So obviously, and again, I think it was at the original May meeting, but mentioned as well in April, that May 22nd has been kind of my goal to get this, allow me time to onboard, but get this to you, understanding that this has been a priority of the organization for quite a while. So within that, thank you very much. All right, so actually all of that was in even preparation for these slides. So let me get now into the ED review process. So that was prior to my arrival. Coming in, I went through an extensive onboarding process. The commissioners, put in place, the chair as well, the chief of staff, the executive assistants, all of the chiefs. Got to meet with a lot of different staff in the first few months here. And so through that process, I've been able to kind of, in addition to learning some of the day in, day out functions of the organization, also get feedback throughout this process, including working with commissioners. So got the opportunity to sort of consider that feedback initially as I was approaching this document. I did also have the opportunity, I spoke with a mediator that the commissioners had originally engaged for this process, to sort of get a sense of the beginning to where it was left, and I was taking on, from my view, additionally some former staff and former commissioners as well. And so it has been an excellent opportunity to get a sense of what folks think is the best way to create efficiencies within the organization and ensure a good day-to-day operation with commissioners and staff. Additionally, a lot of the SOPs that will overlap, and I'll discuss in a minute, were part of that review process because I think a lot of the practices within the organization come into where the draft was previously and some of what I'm looking to suggest we change in a streamlined version. So again, in that streamlined approach, once I got through that process, I have now sent this out 2 weeks in advance of this meeting to commissioners for review. I'll talk a little bit as we get into the document on some of the feedback I have from commissioners in that 2-week period. Additionally, worked with chiefs. Specifically like to thank a lot of legwork in getting some of the changes done for the clean document that you see for consideration for the general counsel and chief of staff, but really all of the chiefs as well took the time to really dig through this and make sure that my approach they felt is appropriate given all of the excellent expertise that they bring to the table. But a lot of hours from general counsel and chief of staff as well to actually make it presentable as you see. So within the streamlining approach, I just want to make sure that everybody's clear. If something is removed from the clean version that's in the packet today, it is not because I have found it to not have merit or that I don't appreciate sort of all of the work that went into that through the years-long process that the AC mentioned. To me, my approach was really to take things that don't belong in a guidance document, a guardrails document, that were probably a little bit more hyper-specific and move those and make sure that they cross-reference with existing SOPs. So it's not to say that they were not valid, it's to say that they don't belong specifically in this exercise and that they need to be in other documents that can be cross-referenced with this. And so I just want to make sure that it's clear in anything that has been removed from the previous version, it's because I believe it belongs in an SOP. And in certain instances, as well as we'll go through quickly, you know, some of them are also just consolidated for, you know, to make it a more readable document. And then I want to sort of highlight a couple of things that I found challenging, having worked with a lot of different government organizations. Things like referring to the commission, where we're sometimes talking about the body of commissioners, or we're sometimes talking about the agency, talking about staff, or we're sometimes questioning whether or not we mean commissioners as well because of the staff-like components of a commissioner. And so I think there's opportunities as we move forward to try to, you know, use terms like board as it relates to the commissioners, like agency as it relates to the organization. I don't think that all of those need to be highlighted right now. I think that as we go through our SOP library, as we go through our policies that I know the CPO has mentioned before and I'm working on with all the chiefs, I think we have the opportunities to make it clearer to external stakeholders, whereas I think our internal stakeholders are used to this language. But it's just something that I particularly found challenging coming in from the outside, where we use terms that might be interpreted multiple ways. If we go to the next slide, I just want to highlight specifically some of the things that I'm mentioning are moved to other documents. So public meeting agenda setting, executive director goals, project work groups, budgeting and budgeting process, professional development. These are all critical. And so I'm not saying that they aren't necessary. I'm saying that in this document, it either is not necessary or can be folded into a section that we'll go through, or that, you know, the SOP essentially covers what the previous version was trying to accomplish. So just as an example, you know, the executive director goal setting is a relatively standard process for a public body with a hiring, managing role for the executive director position. I think the SOP covers it. It does not need to be in here, in my opinion. Obviously, we can discuss that as well. You know, budgeting roles, the SOP is very detailed, I think covers it, and the statute is relatively, in my opinion, clear on the commissioner role with not a lot of confusion. And then professional development is a critical component of what we do as an employer. But I don't think in this instance, I think the SOP process for that is what demonstrates our commitment to professional development. So those are just a couple examples. There are others that you'll see the headers have been removed. Generally speaking, those were then absorbed within other sections, which I'll go through. Next slide, please. All right, I'm not going to go through each of the roles and responsibilities because we can dive into the document, and if there are any questions, I'm happy to get into them, but I just, on the bottom section here, I think the most important sort of guardrail function that I'm trying to access here is commissioners and staff need to work together in a lot of instances, and commissioners in their policymaking role as adjudicators need access to a lot of information, and yet a lot of the resources that a commissioner needs is access to staff time. it is the executive director's role in a lot of these instances to play the central figure, where in certain instances, if we have limited resources in a short period of time, we are needing to prioritize based on the overarching goals of the organization, which get approved on an annual basis by the body of commissioners. And so in instances where there may be conflict of accessing, resources, including staff time, that it is the executive director in certain instances that can play that central role to make sure that everything is moving efficiently, commissioners are getting what they need, and staff has what it needs to be successful, answer the goals of the commissioners, but also their day-to-day functions. So in this instance, we're saying, we need to ensure that commissioners have access to staff and information, but at the same point, we need to ensure that commissioners go through the ED as the head of the agency for access to staff. And we have a number of ways in which we can do that. We have confidential executive assistants that support the commissioners and the ED that can help with that process. We have platforms for requests of information as it relates to I&E to ensure that information being shared is, going through the appropriate firewall under 30A. And so that leads me to this last point on the screen, which is ensuring the 30A requirements are upheld, really to not allow us to be bogged down, to allow commissioners to get what they need, but also for staff to continue on tight timelines. In a lot of instances, it is really important that the commissioners are using the ED in some of these instances, because that is in a 30A scenario, which obviously is not specific to the CCC. There are many other organizations that have similar firewall needs. You really do need that centralized figure. And so I think this document is very important for ensuring that we're doing that properly. We could go to the next slide. I'm just going to high level a few of the sections and then dive into a couple specific items I want to go through in the document. You get the next slide, please. Thanks so much. All right, so for external affairs, this is one that I would highlight has absorbed some of the other sections that were previously broken out that were not moved to SOP. So I think, again, high level, some of the really important things that we're trying to do with external affairs is that commissioners act as spokespersons. And I think one of the interesting things of talking with the mediator and kind of looking at the development of this process is the interest of how this has changed over time. And so I'm just looking at it from a general perspective of what does that mean? And this is how, public bodies work. If you are speaking on behalf of the commissioners, there's a process that you're following because a vote has been taken and you're, disseminating the will of the board. And in certain instances, you as individuals need to be able to speak for yourselves, even if you are not representing the entire body of the commissioners. And so there needs to be a process in place for that, which I like how this version came out, and I hope you do as well, and we can get into that. And then the executive director is generally the spokesperson as it relates to administrative, personnel, and operational matters. And where those things overlap, in general, we might see the ED and commissioners together in those instances. For accountability, checks and balances, I think for the most part, this is where I looked at it externally. I like a matrix format, which is where I'll go for dissemination if we move forward here, where we can kind of see it more visually, but this is in a narrative format. And so I think for the most part, I would say that the majority of internal complaints follow a standard HR process for review, but there are sometimes instances where it can't do that, where there are specific individuals that are tasked with some level of compliance as it relates to personnel complaints. We have to ensure that there's a process that can move forward so that, an individual knows how to move forward a complaint, and an individual knows where a complaint is going after it is initiated. And so in this instance, it's really sort of highlighting instances where a commissioner, the executive director, the CPO, general counsel might be involved in how that process may play out slightly differently, because we all have levels of accountability, and sometimes they look a little bit different depending on where you sit within the organization. So we'll get into that as well, because I do have a recommended tweak from the version that's online. If we can move to the last slide. I just want to kind of high level this. I was going to write a script to kind of cover it because there's so many things that I wanted to touch on. I did not do that. And so this was kind of my last slide to just kind of summarize my general thoughts. The updated governance charter with my recommended changes is intended to narrow the focus for the purpose, addressing how commissioners in their policymaking roles effectively utilize organizational resources, including staff time, to fulfill their responsibilities while respecting the role of the executive director, who must ensure appropriate deployment of operational resources, including personnel, as the administrative head of the commission. Obviously the benefits, one of the things that we talked about earlier with the complaint resolution administrator is that by having this role where commissioners and the executive director have this type of process in place through the governance charter, the benefits is really going to be felt through, improved long-term planning, strategic planning, which the commissioners play direct roles in through the goal setting, and a lot of the pieces that we'll talk about. And in addition, we are going to remain, as far as I can tell, a body that needs to consider 30A with firewalls that impact commissioners, and commissioners need to have access and the ability to continue to do their jobs even through a firewall. And how do we do those things? So that was the approach. And so I want to kind of get into a few things that I've had feedback on in the last 2 weeks since I sent this version, which is available online, to commissioners. I do have a couple printed copies as well, and I know Commissioner Concepcion's online, so I sent her just a couple of red lines to go through. I have a couple other notes that I just want to talk through that are not recommended changes at this time, but just for discussion. And I believe Commissioner Roy had given you a copy. You could pass that. Thank you. And so with that, I'm going to turn. So if people are following along online with the version that's online, I'm going to go through the page numbers on the document. And so the table of contents is not numbered. The first page is purpose, background, and that's page 1. I don't have any notes on page 1. The one thing I'd want to say, some of the feedback I got from staff in reviewing the document is that on page 2 at the very end of the background section, that really the intent here is to ensure that we are a collaborative unit looking to accomplish the mission of the organization. And I think that some of this language is essentially lifted directly from statute and enabling documents. And so I just wanted to kind of highlight that was some of the feedback I got as people look at this, that's really an intent of staff as well, is to ensure that is how we're operating. And I think that, I believe that that's the intent of the commissioners as well. One note that I put in the document and I have made in my one-on-ones with commissioners is on page 3. It is technically under section 1 of roles and responsibilities, 1E Roman numeral 6. And it says approved job descriptions for new and or significantly revised positions proposed by the executive director. I don't have a proposed change to this. I'm just highlighting that this is one that I personally would, coming externally would change slightly because of our discussion earlier on the complaint resolution administrator. To me, the job description is not the most important part of that discussion. I think the acting chair kind of highlighted a lot of the important elements of that, namely budget. I read this as the job description is the mechanism for the commissioners through their statutory role in the process of interacting with the executive director on the administrative hiring process. The job description gives the commissioners the ability to sort of see the changes that the executive director is putting forward. So I recognize it. I think my only trepidation with it is really that the job description is kind of the mundane minutia of the process. And really what I see now that we're 7 years into this as an organization is that commissioners really need to be understanding and working with and approving the major changes that the executive director is putting in place that may have budget impacts, that may have impacts to operations or capacity for the goals that the commissioners are approving on an annual basis. So where an executive director may recommend shifting significantly focus from one department to another, the commissioners have a role in that. So I recognize that the job description here is kind of the mechanism to ensure that that's happening. And yet I think the job descriptions theoretically is probably an outdated way to look at it from the beginning of a startup organization. And so again, I think the budget impacts, the short and long-term planning aspect of reviewing significant changes proposed in the organizational structure is really the intent. And so I just wanted to highlight that. I'm happy to have a discussion on it. And I think at this point, I'm comfortable with that process so long as, I think the outcome today of the CRA discussion is a good example of it's not really the job description. We just need the function to ensure that the executive director is bringing those types of organizational changes to the commissioners for review and approval. So I'm going to skip over that. I'm happy to come back to any of these items unless you want me to stop for discussion of each.
I'm okay if we stop and just kind of go through, since now we're getting into the specifics, you know, and we can stop on E6 under roles and responsibilities. Do you have any recommendations or suggestions as to how you would word it? Again, let's think of this document as not only for the current set of commissioners and the current ED, but if 3 or 4 new people stepped into this role or stepped into your role, would they understand how we envision that as a mechanism to approve? It's a mechanism to approve overall changes in operability to the commission.
Right. So, I mean, I think at a basic level, and I think it may not sort of go far enough for people to feel comfortable that there may be something outside of this, but ultimately it's changes, it's recommended changes from the ED to roles and positions with a budget impact, right? And so I think that what that would then not cover necessarily is shifting, you know, a position or allocation of budget from one department to another that the commissioners may want to be involved in. And so I think that it may be then further, you know, without a budget impact or a change to resource allocation within the organizational structure. I think that's ultimately what the commissioners need to have kind of make sure that they are in agreement with, and not necessarily the job description itself. But I think, you know, if we aren't able to word that, then I think job description is kind of a clunky way to just solve it.
Is there any wording you would want to add around budget impact or structural or operational impact? But
Before we change that and water down that, or, so the executive director and I had a lengthy discussion around this. So in chapter 10, section 76J, the executive director shall appoint an employee chief financial and accounting officer in May. This is the important part. Subject to the approval of the commission, employ other employees, consultants, agents, advisors, including legal counsel. So subject to a statutory change, this is our duty.
Right.
Full stop.
And I appreciate it. I'm just thinking of it. Is there more context you want to put into it? Or are you comfortable with that?
I think ultimately my point is I think the wording that Commissioner Roy just read, if I was starting from scratch, probably wouldn't have selected job description as the mechanism. But I agree with Commissioner Roy's point that the commissioners need to have a role in these types of changes. So one of the things that we have right now is the significantly revised positions. To me, it's the job description. If it's impacting the budget, if we're shifting or impacting resource allocation, those are the things. That is the intent of the statute, and that's what we need to maintain here. And if job description, we don't have, you know, sort of a more eloquent way of doing that, I'm comfortable with it. I just want to highlight that, to me, reviewing job descriptions, as I've looked at other public boards, you know, is generally not the way that we achieve the goal as written in the statute. That's kind of my point.
Let me ask you this. Do we want to, because we don't footnote it here, do we want to reference the statute or make a footnote?
No, it is. It is footnoted.
That footnote
No,
is technically up at the top of E
Yeah,
or
it's
E.
not understood.
So, yeah. Yeah, absolutely. I think if we want to footnote it, that's fine. And again, I have obviously I've made some significant recommended changes here. So I'm doing this more for posterity's sake. I don't have language that I'm suggesting you change it to. It's really more for me. As I looked at this one I struggle with the most. I've talked with chiefs about, but I've also kind of looked at it from how other boards and committees effectuate the same type of statutory language that Commissioner Roy just read. Generally, job description is not it. And I use the CRA as an example of, it's one way to ensure that you're seeing how we're structuring it, but ultimately the real, you know, discussion is about where it fits within the organization, what the budget impacts are. So I think we can come back to it if there's no kind of suggested motion, and general counsel as well. Happy to hop in if people want to talk about potential ways to change it. And I had it in a comment too, so I didn't want to skip over it.
Commissioner, go ahead.
The only way I think you could edit it is literally lift the language from the statute. So if you want to get rid of job descriptions and say that, you know, this falls under in relation to the administrative agency, the commissioners approve the employment of other employees, consultants, agents, advisors, including legal counsel. I mean, I think that's the only other option is to literally lift the language, which does not say job description, to your point, but.
No, and I think job description, to my point, is a clunky way of doing it that I think we can do better, but I also think people are comfortable with it. It's been the process from the beginning. That's why I did not suggest an edit in the version that you have in front of you. I'm highlighting it more for discussion.
Mhm.
All right, so I'm going to take people to page 4 because this was part of my discussion as well. My one-on-ones with Commissioner. I just want to have the discussion again for posterity. I'm not personally suggesting an edit to this. Under the commission chair 2A, I just want to highlight that this is a pivotal distinction within the document. I think one of our core goals of this process is ensuring that we are in a statute related to 5 commissioners and an executive director that has had some level of conflict that has initiated this whole process of getting to a governance charter that's stipulating how the commission chair impacts the affairs of the commission. And in this instance, by serving as presiding officer at all public meetings and hearings, which is consistent with statute, and then having the executive director who's the administrative head. I think we are doing our best to explain how we are operating in an efficient way where the chair has a significant amount of roles and responsibilities, as do all commissioners, and that the executive director does as well. And whereas there is sometime overlap, we are able to in some way define who is doing what. So that one to me came up in my discussion. I don't have a suggested edit. I personally, this is my recommended language, but just wanted to highlight it as kind of a pivotal part of why this exercise is moving us forward. Happy to stop there if there's any discussion or go to what are some suggested edits from the version online. Those are just my 2 sort of discussion.
Were there any certain letters you were like any specific?
I'm talking about specifically 2A, commission chair, where it says exercise supervision and control over the affairs of the commission by serving as presiding officer at all public meetings and hearings. We're just trying to make sure it's clear that there is quite a bit of responsibility of the chair. And generally speaking, that is exhibited through the presiding over all public meetings and hearings. And that's sort of differentiating in some way where the conflict existed in the statute.
Okay, thank you. Commissioner Moore, go ahead.
Chapter 10, section 76, I, the chair exercises supervision control over all affairs of the commission. And you had struck all, which is in statute, and you explained to me you felt that was de minimis by striking all. So, but it says all in the statute.
Yep, and I think if you read that sentence with over the affairs of the commission, versus over all the affairs of the commission, and my point again being that the intent here is to explain that yes, there is significant amount of roles and responsibilities of the chair, and generally this is how it's exhibited, is how we are trying to clear up what has been a conflict in the past while maintaining all of the control roles, responsibilities of the chair. And so again, I mean, I think we can have that discussion on all, but to me, the sentence, the affairs and all the affairs does not read differently.
Commissioner, go ahead.
So in F, can we just go over F, please?
On page 4.
Yes, please.
You want me to read it?
Yes, please.
Okay. Designates a commissioner to act as chair for hearings and public meetings in the chair's absence. The secretary may serve as chair if the chair is absent and has not previously designate another commissioner to act as chair for a public meeting. If a chair is removed or suspended by the appointing authority, the remaining commissioners will elect an acting chair until the appointing authority designates the chair. And that is referencing MGL Chapter 10, Section 76D and H, and also MGL Chapter 94G, Section 4A.
The last, okay, if I may.
Go ahead.
So, chapter 10, section 76H, the chair shall have and exercise supervision and control over all affairs of the commission. The chair shall preside at all hearings at which the chair is present and shall designate. Let me say that again. The chair shall preside at all hearings at which the chair is present and shall designate a commissioner to act as chair and the chair is absent. So the first part of this speaks to that, but now we are making up law. If a chair is removed or suspended by an appointing authority, the remaining commissioners will elect an acting chair until the appointing authority designates the chair. It's not prescriptive anywhere that I can find.
Do you want to touch on it? You want me to?
I'm sorry, and the point here is, I'm sorry.
So under 2F on page 4, I think the point that's being made, if I understand correctly, is that the ability of other commissioners to elect an acting chair while waiting on the appointing authority to designate a chair is not being referenced somewhere specifically, and that we are trying to create the interim process to continue to operate is, I believe, the question of the ability to do so. Is that? Okay.
Yes, thank you, Edie.
Okay.
And I think the reference that we have is to 4A under 94G, which is the commission shall have the powers necessary or convenient to carry out and effectuate its purposes, including but not limited to the power to. So it just references A, but I'm assuming it goes through that string of Roman numerals after.
Yeah, I mean, I guess I'll just say that, you know, the intent here is really not just to regurgitate the statute and to give this document, you know, some more breathing room so that there is this, you know, understanding between all involved that this is how the agency will operate. So that I think that's going back to the intent of what the ED is talking about.
The chair considered an officer, above just the secretary and the treasurer or the officer.
Sorry, that's not a point related to your question, though.
It is actually, well, because he referenced, the acting chair referenced section 4.
Mm-hmm.
And part of that is to appoint officers and hire employees. So
It does reference the chair under statute as serving as the presiding officer at all public meetings and hearings.
so we recognize the chair as an officer.
But I think to your point, for footnoting, it should be 94G 4A numerat 1.
That's correct.
And so I think to Commissioner Roy's point, but I would just clarify as well for those following along, is the question really is the process in place to replace a chair is currently the responsibility of the treasurer. This is talking about how we would operate in the interim prior to a chair being.
Yeah, it's the handing of the power baton, and it's statute it's prescriptive, how you hand off the baton. So the chair and the chair's absent. So you were absent, you would delegate someone in your absence, you hand the baton off. That's in statute, right? But what's not in statute is if a chair is removed or suspended by an appointing authority, the remaining commissioners will elect. So we are creating how to hand off the power baton, which is, we're creating it.
Only until such time that a new chair is appointed.
But I just want for the record to say, like, it's not prescriptive anywhere, and we are creating this. So
If I may,
handing how to hand off the power baton.
Go ahead, Commissioner.
Commissioner Ward, I hear you and I understand, but I feel like this was what we discussed amongst ourselves in executive session. And we were using the consensus model. So I hear what you're saying. And this was, this is a big topic here. I see it as both process, like not the whole process is in here, but both of them are in here. And this is something that we all decided as commissioners. This conversation here, the secretary may serve as chair if the chair is absent and has not previously designated the commissioner to act as chair for a public meeting. If a chair is removed or suspended by the appointing authority, the remaining commissioners will elect an acting chair until the appointing authority designates the chair.
Right. Until the appointing authority.
But my question is, what we're making up, does that override? So you hand off the power baton, something happens, so now that overrides the statute. The made up rule overrides the statute. And that's my concern.
I'm not seeing the scenario. Sorry.
There was a scenario.
Well, so
We won't revisit that.
but just through the chair. So again, I'm just concerned that it sounds as the way that you're referring to it is that this is the commissioners selecting the chair. And this is not the case as this reads. This is the commissioners selecting the chair until the appointing authority designates the chair. So that in an instance of needing to call a meeting of other commissioners in this scenario, that a chair can be put in place so that a meeting can be called until the appointing authority designates chair. So it is a short-term scenario that's being set up here that you're referring to. I just want to make sure.
So let me just play devil's advocate a little bit. So the chair going in for an operation, let's just say, or not you, think everybody well, good health. And so the chair will be incapacitated, designates an acting chair. Well, that doesn't go well in the operation. So now what happens? Is it still that designation? Does that still stand under this? Or now we're waiting? Is it only when suspended, then we go to a vote? The chair's incapacitated, hands off the power baton, doesn't come out of incapacitation. So what happens now? Does that power baton still rest? Or is it only under the circumstance of suspension, which is we created, kick in?
If I can, since apparently I'm going under the knife. So the previous provision, if I'm hearing the scenario you're talking about, secretary may serve as chair if the chair is absent. Assume that would also extend to incapacitated.
Oh.
And let me finish that point and I'll get to the next one. And has not previously designated another commissioner to act as chair for a public meeting. So I'm not anticipating anything, but I can't be at a meeting. I'm under the knife in your scenario. The secretary, we're giving the authority for the secretary to serve as chair. The next, and I would read that and certainly invite comment that if that continue to be a longer absence, I would read that as the secretary would still continue to serve as chair. Under the next provision where it says if a chair is removed or suspended by the appointing authority, the remaining commissioners will elect an acting chair until the appointing authority designates the chair. And we, again, footnote 94G 4A, which, gives the commission the powers all the powers necessary or convenient to carry out and effectuate its purposes, including but not limited to the power to appoint officers. And again, I look at that as, I think ED reflect on it. It's a temporary fix, because there is work that includes, deny an application for a license or establish register. It allows the work of the commission to continue. But starting off with that authority that the commission has to elect an acting chair, again, not taking away the appointing authority, in this case, the treasurer to designate a new chair or designates the chair. Go ahead, Commissioner.
Thank you. Could you walk through that entire scenario if you pass the baton, let's say the treasurer? Can you just walk through that again? Say the secretary, I don't want to do it. You're going under the knife, you pass it to the treasurer, and what happens?
What are you talking about?
Just exactly what you said.
Yeah.
Only you passed the baton to the treasurer because the secretary declined. So the treasurer, so then what happens? You're incapacitated, and now what happens?
I would read this as whoever the chair has designated. If the secretary turns them down or turns the chair down, unless, I would assume then that you go back to the previous one. I have the chair can designate a commissioner to act as chair for hearings and public meetings in the chair's absence. Separate that designation, a secretary may serve if the chair is absent and the previously designated, and I haven't previously designated or asked anybody else, they continue to serve as chair for a public meeting. If the chair is removed, the kind of third scenario now in this, I guess, the remaining commissioners will elect an acting chair until the appointing authority designates the chair.
So we made up something that will override the statute. So if you pass the baton to the treasurer, you think you're going to be out for 2 weeks for an operation, you're incapacitated.
Mm-hmm.
Does that memo, that delegation now is going to get override the statute, and we're going to make up something to override the statute? So you pass it to the treasurer, I'm out for 2 weeks, see you in 2 weeks. Something awful happens, you're out. So there's a delegation and a power baton has been passed. But since you're incapacitated, you're removed, but that delegation still stands. So you're saying we have the authority to override the enabling statute. That's what I'm hearing.
Not interpret it that way. And again, I think the issue as it relates to, these are all individual sentences. The final sentence, I think, is the scenario that you're referring to, but we're talking about temporary instances and where an instance becomes more permanent, where a chair is not going to return, then it's going to go to the appointing authority to elect a chair. So this is setting up ways in which we continue to operate where we may have an impact to the chair. So I think it's not overriding the statute. I think it's offering us ways for interim ways to continue to operate until the appointing authority is able to name the chair.
But do we already have a procedure in place? If the power of Thomas passed the treasurer, we already have a procedure in place to operate.
This is laying out numerous scenarios, though.
But being creative with the statute, I would say.
I think the concern, and I'll say separately from this document, one of the things I worked through as well, it stipulates here that I will be at all public meetings, to which my point was, I certainly would hope that, if there's an issue that requires a meeting that I can't attend, but obviously the general counsel or another, of our excellent staff are able to assist the commissioners, that's not necessary. I think in certain instances, and this one included, what we're talking about here is, that the appointing authority may take a while, especially if it takes time to figure out whether or not the chair is coming back from the surgery you just put them through. The treasurer may have to. The treasurer may have to take action as the appointing authority of the chair. And so, you know, that in that instance, if there is business that needs to be continuing to do, we're having a process to allow us to continue to do that. That's how I read it. I don't personally say that it's overriding, and I'm not sure, General Counsel, if you have a different opinion.
And no, I agree with that statement.
And I mean, you bring up a good point, and it's a good question for us to have a conversation around. It's I look back on section 4 and 4A, under 94G, the commission shall have all the powers necessary or convenient to carry out and effectuate its purposes, including but not limited to the power to appoint officers, hire employees. Again, I always looked at that, and this is similar language from the gaming statute.
Right.
It was giving us essentially resting with the commission an ability for us to decide, obviously with a lot of parameters, but allowing us to decide how to move forwards with certain scenarios, and certainly to make sure that the business of the commission and our obligations didn't necessarily lapse. So, you know, I think designating, you know, allowing the chair to designate, you know, somebody to, you know, act as chair of public hearings if I know I'm going to be out, certainly a scenario, you know, we worked through at the Gaming Commission. I don't think we ever had a case where the chair was absent unexpectedly and had not previously asked another commissioner to serve as chair for a public meeting. I think this was, through our collective discussions, the safeguard by turning to the secretary. And then obviously in the case of somebody being removed or suspended by the appointing authority, the remaining commissioners, obviously, again, if it's the chair's position, the remaining commissioners have the opportunity to elect an acting chair, again, to go back to 94G 4A, so that we can continue to get the work done. And part of that authority, you know, includes the ability to appoint officers. But go ahead, Commissioner.
So, for instance, for your designation, that was a letter we received from the Treasurer and Receiver General.
Mhm.
So that's not baked in here either. So your scenario currently was designation from the Treasurer and Receiver General. That's not contemplated in here either.
The elected acting chair under the appointing authority designates the chair.
The appointing authority. Yeah.
Would that cover it?
What was that? I'm sorry, Commissioner.
Just if I may, Commissioner Stebbins,
Go ahead, Commissioner.
the last sentence in F, commissioners will elect an acting chair until the appointing authorities designate the chair. So the appointing authorities came in on Commissioner Stebbins' situation, so this covers it.
Sorry, go ahead.
Yeah, no, I agree with that reading that Commissioner Camargo just made. That does cover the current scenario that the commission is operating under. Obviously, the statute, any statute can't imagine every single scenario. And I think we're talking about trying to come to a resolution, an interim resolution in situations that aren't explicitly addressed in statute. I think that's the intent here.
But I would add to that argument, 4A does give the commission,
Correct.
as we see fit, the powers to, again, to continue to effectuate the work of the commission and our responsibilities. So, but I think to that last part, I've been designated an acting chair. I'm not a permanent chair. So, but that was made clear in the appointment letter that I think she issued. Go ahead, Ian.
I do have 7 suggested edits to the version online that I just want to be able to kind of make sure that we get through. If you want me to go through those and then return to any discussions. Obviously, the job description and those things were just things that I wanted to make sure that we discussed for posterity and for the sake of the discussion. Some of these changes came out of when I socialized this document, especially to the commissioners in the last 2 weeks, to ensure that people feel comfortable that some of the things that were either removed or consolidated within the document didn't get lost. So on page 5, under item 3, which is the commission treasurer, subsection C, subsection Roman numeral 2. It reads, conducts regular review meetings through the executive director with the CFAO and fiscal staff to discuss budget extensions, revenues, and fiscal issues such as rate of spending or any unplanned costs. One of the things that was a separate section that was caught elsewhere, and I think may fit within fiscal issues, but was requested to be separated and called out specifically, would read to discuss budget execution, revenues, department resources, and fiscal issues such as rate of spending or any planned costs, which is a change that I would certainly support. There's no discussion, and I'm going to go through them, but just flag me down if you need me to stop on any of these. This is one on page 6 under 5, which is the executive director F. This is one that I sort of battled with a lot as well and relied on staff to kind of talk through as well. So in a timely manner in F is an issue that we use elsewhere in the document, so it certainly has a place. My concern was, one individual's expectation with timely manner may not be mine, and it leads to theoretically additional conflict, whereas we're trying to address that. So I had replaced in a timely manner with as soon as circumstances reasonably permit, for the specific reason that while we may disagree on what a timely manner means, I can explain my reasoning for the time that it took, should there be a question of when I got you information. So the compromise that I think works perfectly fine, may be slightly redundant, but I think is perfectly appropriate, would be alerts commissioners of urgent public health, safety, and welfare incidents in a timely manner as soon as circumstances reasonably permit. So the timely manner we use elsewhere, it's a perfectly fine stance. I just want to be clear that we may disagree on timely manner. I'm always going to be able to give you a reason of why I've provided information to you when I did. So I think it works together. It might be a little wordier, but I think that it can work that way harmoniously as well. Okay. Page 9, which is so under interactions between and among commissioners, executive director, and staff, starts on page 8. I'm on page 9, number 6. Within this section, there are 2 sentences that both touch on different ways in which communications are going. In one instance, it says through the executive director, in the other instance, it doesn't. To make sure that it is clear that at any times that there's a conflict in this, that the central figure to make sure that there's a resolution is the executive director, it would be to ensure that through the executive director is written in each sentence. So rather than how it's written online in the packet, this would be the reading with the adjustment. Commissioners may contact through the executive director a topic sponsor of a public meeting agenda item in preparation for a commission public meeting. Sponsoring staff may also request time to brief commissioners through the executive director in advance of the public meeting. If the sponsor is a commissioner, the open meeting law applies. I just want to make it clear to anybody out there who's saying, wow, everybody's just CCing the executive director on everything. It's really just to ensure that if there is an issue that arises, that the ED is there to play a central figure if necessary. But obviously we have so many things going on. There's so many instances that, we have communications going. It's really just to ensure that we're addressing should there be conflict. And so you'll see through the executive director quite a bit throughout the document. Really more, again, as I mentioned in my introduction, we have the processes in place where we have, our confidential executive assistants, we have, forms in line to get information. So we have mechanisms in place. This is really just about being consistent to ensure that, commissioners and staff are working harmoniously. And if not, that the central figure is the executive director, and then we can move on from any issues. So I thought that was a good point that makes that read consistent throughout. Moving 2 down from that on number 8 on page 9 is that the way it currently reads is simply review and approve a project charter. Now, a project charter has many of its own elements written within it of how it may, change over time, but also within this, this writing previously may have stated it in a way that sounded like it was set it or forget it. The executive director is gone, but in many instances, the executive director has to make changes to the charter, be involved in the charter, be involved in the process. Maybe the charter gets unwound. And so with this, it would be to change it to read a project charter, which must be reviewed, approved, and overseen by the executive director, allows the commissioner and staff interactions based on its project scope and staff resource allocations. Not all projects initiated with project charters may include commissioner participation. There's certainly project charters that don't include commissioners. In many instances, they do. And this is just saying, in addition to review and approve, that there's a level of oversight that may have, changes throughout that process. So that is additional change that came out of my discussions with the commissioners that I think is a value add to this discussion. On page 10, this is an example of items that were consolidated or moved around because they exist elsewhere. But on number 13, at the bottom of page 10, we say that the commissioners, executive director, and staff are committed to compliance with the Massachusetts open meeting laws, including restrictions on serial communications with or among more than 2 commissioners, adding comma rather than period, and will attend annual open meeting law training sessions. That was within the professional development section that I've sort of moved either within other sections or to SOPs. And so just want to make sure that it's codified there. Obviously, the open meeting law is a significant part of what we do for this commission as well. And so where, we just talked about communicating with commissioners, it's very important that it mentions the serial communication because we are, very cognizant and we put a lot of effort, the commissioners do as well, in ensuring that we are not having the serial communications that goes around open meeting law, but the attendance of open meeting law training sessions on an annual basis, I would feel comfortable adding there. I think adds value to the existing draft. One last one before, these last 2 are a little bit more sort of significant. So let me just kind of tee this up. If I get to page 12 and 13, which is now in the accountability checks and balances section, one of the things we want to ensure here for our own staff internally that may have a complaint or allegation that they need to feel confident is progressing through a process, similarly to somebody who may feel like they want to understand if a complaint or allegation was made against them, how that process is going to work. The accountability checks and balances section is a significant portion of this document. For us to move forward, one of the things that I want to make sure is that the treatment of individuals who are called out specifically because of their roles that fall outside of the majority of staff, such as the executive director, commissioners, CPO, and GC, that all of those are called out specifically because they may play specific roles and may have different ways in which those complaints or allegations must go up a chain of command. So in the way that 4 and 5 are written, it was pointed out that a complaint or allegation made, so 4 is against the commissioner and 5 is against the executive director. Whereas 4 stipulates that an allegation or complaint would be investigated, how it would be investigated, and if found to have merit, be brought by the executive director to the appointing authorities, which is the accountability structure for a commissioner. In the executive director example in item 5, it did not indicate that something found to have merit would go to the entire body of commissioners, as it was pointed out from the way that this reads in the online version. And I agree with that. The answer is that similar to a complaint or allegation of a commissioner not going to an appointing authority if it is not found to have merit after review, similarly, we wouldn't want any allegation against the executive director if review did not have merit to just go to all of the commissioners. But should it be found to have merit, it doesn't just go to the chair. All of the commissioners additionally are the accountability for the executive director. You all hire, fire, and discipline or terminate the executive director. So I think that the version that I'll read right now clarifies that process to ensure that it is consistent of a commissioner or the executive director, which I think is very important for sort of this exercise. So in 4, the final sentence, well, I'll read the whole thing because I think we need the context. So in number 4 on page 12, if a complaint or allegation is made against a commissioner, and there is a concern that the commissioner's conduct may be in violation of federal or state law, commission governing laws, or commission approved policies, the executive director, general counsel, and chief people officer will conduct an investigation and determine an appropriate course of action in accordance with the employee handbook. The executive director, and this is where the change comes in, the executive director shall determine if the complaint or allegation holds merit and decide on notification of the appointing authorities, and will notify the commissioner whose conduct is at issue and the chair if not the subject of the complaint. So it is the determine if the complaint or allegation holds merit, which now will mirror the adjustment to number 5 that I'll read next.
Just quick, there's a spelling error on the red line of complaint.
Yes, it should not say compliance. That is,
Channeling.
okay, thank you. All right, so now 5 is now talking about the executive director, which obviously follows its own process where those individuals responsible for any course of action against the executive director based on a complaint or allegation would be my bosses, which are 5 commissioners. So again, it is spelled out slightly differently than a normal HR matter that would just simply go through HR. Similar to the one that we just went through with commissioners, we have to explain what the accountability structure is. So for an executive director, if a complaint or allegation is made against the executive director, or there is a concern that an executive director's conduct may be in violation of federal or state law, commission governing laws, or commission approved policies, that matter will be referred to the chief people officer and general counsel. Chief people officer or general counsel, or general counsel. That gives individuals within the organization the ability to have options. So I think it's important that people understand where they can go should it be about the executive director. The chief people officer or general counsel will conduct an evaluation in consultation with the chair as the point person for the commissioners, and if necessary, will conduct an investigation and determine if the complaint or allegation holds merit. And if it is determined to hold merit, then refer the complaint or allegation to the full body of commissioners to determine an appropriate course of action in accordance with the employee handbook. So again, now we've tried to make sure that it is clear that we are mirroring that if it is found to have merit in a commissioner instance, it is going, the executive director is making the decision to bring it to the appointing authority. In the executive director instance, general counsel and or CPO are reviewing it. If found to have merit, working with the chair, are bringing it to the full body of commissioners. So I think both of those are value adds, but they are somewhat more structural than the other ones I just breezed through. So I want to make sure there are no questions on those suggested edits.
Any questions or comments on the, let's start with the red line edits. The ED Incorporated. Commissioner Reagan.
Thank you, Chair. Well, I just want to pause and first, thank you, Acting Chair. We spent over an hour yesterday, and I want to thank Executive Director Ahern. We spent 2 hours on this document. So I want to thank you for really robust discussion around these different items, and thank you for listening and for all the time that we spent on this document. So once we get past this, I do have some comments I want to make on the overall process. I don't know if we're ready for that, but I just want to take this time to thank you both.
Thank you.
Thank you. I do just so we're keeping track of notes and comments as we've gone through the changes, just to note, I think we got to go back to page 4. I think we're left, maybe I'm unclear, under 2A, the commission chair exercises supervision and control over all the affairs of the commission. You had mentioned all had been removed. You gave an explanation why. I guess my question for commissioners is, do we want to put the all back in to make sure that it mirrors the statute, or is there a preference? I'm okay with putting it back in to mirror the statute, but I also know that I think we footnote the reference to the statute, so.
As the acting chair, what do you prefer?
If we're gonna reference the statute, I think it's okay to put it back in.
And again, I think just for the previous discussion, I think the most important thing for our exercise of kind of moving forward and making sure that we're differentiating and understanding roles and how we collaborate, it's the by serving as presiding. So all, to me, with or without in the sentence, reads the same to me. So I have no opinion personally either.
And then to the further discussion that we had under 2F, let's just be clear on the footnote. Again, if this is appropriate to reference the footnote at the end of F, which is 8, to be, and I'll look to JC to make sure he concurs we reference 94G, section 4A, Roman numerat 1. Want to get that specific?
If I may,
Go ahead.
yes, that is the appropriate site, so no issues there.
Okay. All right, I have, within this version, if there was going to be discussion on this, the red lines that I just went through, I have the version that we have printed copies of. And then 2 additional changes right now on page 4. One reads 2A, exercise and supervision and control rather than it says over all affairs of the commission. And then within that, the note on the bottom, which is number 8, will now read GL chapter 94G, section 4A, subsection I. Roman numeral 1.
Roman numerat I. Yep. Commissioner, go ahead.
Executive Director, I think at one point we talked about footnoting the SOP library.
Yes, that was one thing I had as sort of a final discussion here. In addition to, looking throughout this document in the future, which I think is, again, a future discussion on the use of, agency to describe the body and board for the commissioners. I think there's a number of things we can do. My only concern, and I just want to make sure as we work it through that we can do it appropriately from a formatting perspective, is that the SOP library is technically on our intranet, not our internet website. And so where this document is obviously a public facing document, I just don't want to have any links that are not public. So as long as I can come up with a way to make that happen, I think the discussion that Commissioner Roy and I had is that a number of instances where I'm saying some of the topics that we had previously discussed are in SOPs and therefore not here, to reference how to get access to those SOPs. We are looking at that SOP library and reworking it. So I don't have a concern with the proposal. I like the proposal. I just have a concern with right now me putting a link in here that would be active for an external stakeholder. That's all.
The other one item I would turn to, I just want to make sure my colleagues have consensus as quickly as you were moving through the red line changes, and we didn't want to stop you. The bottom of page 6, 5F, this is under the executive director. Obviously, there was a lot of discussion around the language around this because of one past experience that the commission experienced. I just want to make sure that everybody is comfortable with the addition of in a timely manner, as well as what I see as an opportunity for the executive director to say, I notified you as soon as possible as circumstances reasonably permit. So that's, again, language around a matter that we're all familiar with. I just want to go back to that, make sure everybody is comfortable with it.
Makes sense.
All right. Any other? That was a note to myself. Again, just the grammatical change on page 12. Those are all the red line edits. Commissioner Roy, I think we're done. If you wanted the floor.
Yeah, and thank you. And I do want to thank everyone, and but I do have to, on one hand, I want to thank everyone. On the other hand, I just have to express some reservations that I have, and I would be not true to myself as a commissioner if I didn't. So bear with me, and during this process, and I've said consistently that although there was a good faith effort here, it's a Band-Aid. It's not the cure. Really, the cure lies within a statutory fix. And we all know where the rubs lie in the statute. So, yeah. And so, and I've been consistent on that right along. So I just want to say that again, for the record. And my other area of concern is around the process. And we met 16 times we convened an executive session pursuant to Massachusetts General Law, Section 30A, Chapter 30A, Section 2, Section 21, sorry. And so when we convened an executive session, what was the intent? Why did we decide? Why did we feel we had to do this behind closed doors? And, you know, I've asked to go into executive session for other purposes and was told no, because it doesn't fit squarely into one of the exemptions. And there are exemptions with open meeting law. And, you know, people file complaints, and we've had other complaints filed against us, and we did in regards to this. And a few days ago, we received a determination from the Attorney General's office. And if I may read into the record part of the letter, which says public bodies may enter into closed executive session for any of the 10 purposes enumerated in the open meeting law, General Laws, Chapter 30A, Section 21A. The 10 executive session purposes are exceptions to the general rule that meetings of a public body shall be open to the public, and as such are narrowly construed. Among the 10 purposes for executive session is Purpose 9, which allows a public body to convene an executive session to meet or confer with a mediator as defined in Section 23C of Chapter 233, with respect to any litigation or decision on any public business within its jurisdiction, involving another party, group, or entity, provided that 1, any decision to participate in mediation shall be made in open session, and the parties, issues involved, and purpose of the mediation shall be disclosed. And 2, no action shall be taken by any public body with respect to those issues which are the subject of the mediation without deliberation and approval for such action in open session. Well, we received a determination from the Attorney General's office based on a complaint filed. And the complaint questioned that us convening an executive session was not a dispute between two parties, nor mediation of a lawsuit. So the AGO's office said, we agree that the commission's discussions were not appropriate for executive session. During the executive session, the commission reviewed in detail a draft governance charter and discussed at length issues related to the governance and culture of the commission. The fact that the commission was not conferring, quote, with a mediator as defined in Section 23C of Chapter 233 with respect to any litigation or decision involving another party, group, or entity. General Laws, Chapter 30A, Section 21A9. The commission convened an executive session for an improper purpose, and because such discussions should have instead be held in open session for public to witness. So I wonder what the process would have looked like if we would have done this 16 sessions in open meeting as we should have. And I wonder what the staff feels if they could have seen it, participated in it. And yes, we did bring parts of it out for public session, but the cake was 3/4 baked. And I'm not speaking for all staff, but I wonder, would they have liked to have been part of this in some way if we did it in open session? And Commissioner Carr, you even said, we talked about this at length, you know, passing of the baton, but that was behind closed doors, and we needed to do that in public, and we didn't. And Travis, you just said open meeting law is vital to everything we do. And thirdly, right in the document, the commissioners, executive director, and staff are committed to compliance with Massachusetts open meeting law, and we've already violated the spirit of it because we weren't supposed to convene for 16 times behind closed doors. And since I've been commissioner, I've talked about transparency constantly. So I'd be hypocritical if I voted to ratify this. So I'm going to vote present because I feel, you know, everybody did put a good faith effort. We just kind of went around it, went about it in an improper way according to the determination of the AGO. And again, in the spirit of transparency, I felt it was important. I know we're going to talk about it in June, and thank you for putting that on the agenda in June. But I want to put context around why I'm voting present today, because in the spirit of transparency, what would have this looked like if we had those discussions publicly and people saw that, not like a, almost baked product. So I just, in the spirit of candor and transparency, I needed to share that with you and let you know I will be voting present, and that's why. Thank you for my time.
Of course. Thank you, Commissioner. Let me just first see if there's a commissioner that wants to offer comment. Not closing the discussion. If commissioners want to take a minute, but GC, I'll turn it over to you.
Yeah, thank you. I just thank you, Commissioner Roy, for your comments there. I do want to point out just one thing, that the 16 executive sessions that you reference, we have made most of those meetings available. They've been online for many months now. So at least 95% of those meetings have been available to the public to watch, to stream at their convenience. So the suggestion, I just want to clear the record here, that it is not as if, there are these whole meetings that are just, shielded from public view. That is not the case. Most of these meetings, some of them have been released in their entirety, and the others have been released with very minimal redactions under a good faith application of the public records law. So I just want to add to your commentary on that, just so that the public is aware that there aren't just large tranches of meetings that are just sitting in a back room somewhere and not available for public consumption. Thank you,
Commissioner.
Thank you, General Counsel, and thank you, and I appreciate that. My consternation is with that 5% that's still being withheld, because we were supposed to do this in public meeting, public session. So how is there justification to withhold the 5% when the Attorney General's office said this entire exercise should have been done in public? Why the holding back of that 5%?
Yeah, I don't want to get into back and forth here about this right now. I know this is on the agenda for the June meeting. We can talk further about the circumstances behind these executive sessions at that point. I just do want to say that I don't want to be quoted as saying that 95% of the meetings have been released when it could be 99%. So, I just don't want an artificial number to be thrown out there. We have done everything that we can to make sure that whatever is appropriately released to the public, we went through laboriously. The legal team as a whole spent many hours, hundreds of hours as a group, going through these recordings to with an approach to make as much public as possible. And we did that in good faith. And so, again, just want to keep it there.
ED, go ahead.
And I appreciate as well, I think Commissioner Roy mentioned, the time we took yesterday to go through everything, the point on the Band-Aid versus the fix. I personally understand where that's coming from. And I think, as we've continued to have this discussion, as I came in, as we have had discussions, including Commissioner Roy as treasurer on the budget, as acting chair and I have been up there on the Hill talking through legislators. I understand that this may not structurally fix some of the issues we are trying to in this exercise, which I have appreciated, and having the opportunity to work with the commissioners and staff on, really try to indicate that in what we have as current statute, this document improves and makes clear certain aspects that allow us to be more efficient as an organization. So I think it is absolutely a worthwhile exercise. At the same point, getting it to the finish line, I've been involved in far less of it than everybody else, right? So from my perspective, it's been a worthwhile exercise. I understand the frustration, though, in terms of the amount of effort for a Band-Aid versus a fix, but I think it's an important Band-Aid, I guess would be my response to that. And additionally, within the initial discussion and presentation here, I respect your point that you're referring to, would the process have looked different overall? As again, somebody who came in, interviewed with you all in October, started here in March. that I was reviewing this document long ago as the commission put it up available online, is at numerous public meetings as well. And so within the spirit of the AGO's recommendations as well, we are having this discussion today here in a public meeting. And I think, you know, your thought process on this is an important one for the record on the discussion. And yet I still think, you know, the merits of the document itself and what it does for us as an organization is still very significant.
Commissioner Roy.
And I do appreciate that. Thank you, Acting Chair, and thank you, ED. And when you interviewed, as you referred to, you had already reviewed the document, which was very impressive. And I want to thank you for your time, because I kept saying, like, we need to give you time with this. We need to give you space and time to review this. And you did very thoroughly. And I think you made substantive changes in a positive way. And I want to thank you for that. And our 2-hour session yesterday was great too. And I appreciate you taking into account my concerns. So again, I applaud everyone's good faith effort. I just have consternation around the process based on the determination that we received. And, you know, obviously the statute is where the real tension lies. So thank you for hearing me out. Thank you.
Thank you. Thank you, Commissioner. Yeah, and Commissioner, thank you for your comments. Thank you for the time you gave me, and it was kind of during our regular check-in, and it went in a lot longer, and that's fine because this is important work to get done. You know, just a couple, you know, comments from me, you know, and you know, you pointed out the Attorney General's office determination on our use of executive session for these purposes. Again, a very long process. I think for me, in, you know, if you do remember in some of those early sessions, staff were involved and included. Many of those staff have since moved on and pursued other opportunities or made career changes. I do want to give, you know, you know, kudos to the executive director for taking this. And again, we set this as a near-term goal for him, but he quickly jumped in and engaged with staff to look at the version that we now see in front of us, again, with some minor tweaks that have just been made recently that I'm in support of. You know, the Commissioner, you pick up another good, well, let me finish. So we had the determination on the use of executive session, and I get that. I think where I find, what I find important is that the subsequent work, even though a lot of work was already done to prepare a document for us to work on in public, if I think back to that meeting in September, even though it could have been viewed as almost fully baked or ready to go, there were still a number of pins that were put in this document that, again, I express my thanks both to you and Commissioner Camargo and Commissioner Roy for going back and working with legal to resolve those pins so that we could bring it here today. And again, a lot of that work has ultimately been done in public open session. I hear you on your other statement, and I would echo that of, you know, and echo the comments of the ED. You know, we know there's a rub intention in the legislation, which was the initial force for what initiated this process. I can tell you it is almost similar language to what the legislature created for the Gaming Commission. And, you know, we set out on the task of trying to dive into the statute, and where it didn't conflict with the statute, set obligations and responsibilities aside to both commission and the ED. And I think even expand upon that to include other key members of our staff. So I think we've definitely gone beyond the solution I originally thought we were going to try to solve, to engage more of the commission, engage more of the staff. And a lot of that was born out of our experience working with the team up until that point. I think a lot of us contributed things mindful of our engagements with staff, mindful of our engagements with the team, and wanted to make sure those were incorporated in here. But I hear you going forward. There may be a legislative fix at some point. I don't think that necessarily needs to deter us from approving something so that in the interim, however long that interim period may or may not be, to, I think as the ED points out, to allow the work of the commission to be hopefully done more efficiently and more effectively kind of in the period going forward. But I do hear you. We do know that it would be welcome to get some fix and we've talked about it for a number of years, get some fix and or clarity from the legislature. Commissioner Camargo or Commissioner Concepcion? Commissioner Camargo, anything you want to add? And then I'll turn to you, Commissioner Concepcion.
I think you've said it all.
Okay.
Yeah, I'm not going to re-add. I think we've had a lot of conversation. Commissioner Roy, thank you. Commissioner Stebbins, thank you. Commissioner Concepcion, thank you. Everybody who participated in executive session. Travis, thank you for coming in and looking at this with fresh eyes and, chopping it up to make it more effective and really, it's not the end all be all, but I think it's going to give some clarity for everyone. I think we've been functioning very well. But it's going to allow more clarity, especially for commission staff and for, future commissioners. So I'm grateful for the process and thank you.
And future EDs.
And future EDs, of course, not anytime soon.
Not that we're talking about anything quite this early. Commissioner Concepcion, go ahead.
Thank you. And ditto on the part of thanking our executive director for doing a thorough review. For your suggestions and your red line. I had a high level question. I know that we have given different versions of our governance, the draft, to the appointing authorities. And I wanted to know if we've received any sort of feedback up until this point in terms of what we've developed here.
I can answer part of that question, and I know probably the ED wants to chime in on some other interested stakeholders that have wanted versions of it. I believe we have shared some of the most recent versions. I've certainly had conversations with them about moving to complete this work and move to approve the charter. So they've all been appreciative of that. Haven't really delved into too many questions, but depending on how we act today, we'll certainly send them around a new version once we clean it up for some of the ministerial and grammatical edits. But ED, do you want to talk about other folks you've talked to about this document?
Thank you. Absolutely. I believe there was a period where the version that was close to the version that I read as an applicant for the role had been shared with the appointing authorities at that time. So there is no record that I have of any sort of formal written response or suggestions on that version. So I did not have anything to incorporate there. In terms of where we are now and the approach that I had discussed with the commissioners and the goal setting and with staff, we've had a few different conversations between the appointing authorities who have had the opportunity to meet and discuss kind of the approach. And as well, General Counsel and I sat down with the Inspector General, Deputy Inspector General, and involved in that discussion as well was the path forward on the governance charter. I think 30A, for example, was probably the most significant discussion that we got into, where 30A, again, impacts a number of other state agencies, not just the CCC. So I would say, I'm excited to share a version that has all of those discussions and input within it. But as of now, there was never, as far as I was able to ascertain, any sort of written response or feedback on the previous version. So excited to kind of take it to the next step now after some of the discussions and feedback that we got in the process of my being able to meet with a variety of different external stakeholders.
That's helpful. I can share if I may.
Of course.
I think at least my line of thinking was just making sure there was an opportunity presented and that they have the information that we're reviewing. So that is good to know, and that answers my question. Thank you.
Any other comments from commissioners? ED? Commissioner Roy? GC? Okay. I would like to seek a motion to approve the governance charter as amended, subject to ministerial edits. Would you make such a motion, Commissioner Camargo? Would you second it, Commissioner Concepcion?
Second.
Okay, motion been made and seconded. Any further comments or questions? And I also want to echo my thanks to all of my colleagues, our ED, our GC, and staff that have been part of this long process. No other comments or questions. I'll do a roll call vote. Commissioner Camargo? Aye. Commissioner Concepcion?
Aye.
Commissioner Roy?
Present.
And Commissioner Stebbins votes aye. 3 in favor, none opposed, 1 present. Okay. Thanks everybody for their good work. Just related to this, obviously, the letters that we got from the AG's office, which we'll go over in a little more detail in our June meeting. Obviously, there were a number of recommendations in there. I've reached out to the AG's office to try and schedule a more thorough and extensive training from the OML staff that might actually go beyond what was put in their recommendations. And we can talk about that. Hopefully have an update for you when we reconvene on this in June. All right. Commissioner Roy, go ahead.
Under new business not anticipated, I just have to share something really quickly. We're at that point.
Okay, hang on just a moment. Yes, that is the next item, new business not anticipated at time of posting.
Okay, thank you.
Go ahead.
So it was brought to my attention via Danny Carson. We all know Danny's work around worker safety and public health and safety, that there was a voluntary recall in a neighboring state on a product. So I want to thank our I&E team, working with Chief Kamala Jones closely on this, and our team was right on it immediately upon learning this information. And we did further due diligence review to make sure it wasn't marketed under a different name or strain. Or so I just want to let folks know that the voluntary recall in a neighboring state had no impacts in Massachusetts. So I just, from a public health standpoint, I just want to share that information. And I want to thank again Chief Jones and her team for their rapid response and due diligence in this matter. Thank you.
Okay, thank you, Commissioner. And I was copied on those emails and is always impressed by how quickly our team turns around, has information available to us. Next time is next meeting date, which today would be at 4:30. But our next meeting date after that is June 12th. I am also holding on commission calendars right now, tentatively June 17th and 18th, to get back into social consumption reg discussion. Again, those are tentative dates at this point, but you see the dates through the rest of the year as we have them. Obviously, I expect some of these dates to move or new dates to be added as we think about regulatory hearings, regulatory discussions. So with that, I would entertain a motion to adjourn. Do I have such a motion, Commissioner Camargo? Do I have a second, Commissioner Roy?
Second.
Motion made and seconded. Any further comments or discussion? Seeing none, roll call vote. Commissioner Camargo? Commissioner Concepcion?
I actually did have one comment.
Yes, go ahead.
I'm sorry, this is a comment that may have fallen under new business. I'll think through and have more during maybe our next day of public meeting, but I just wanted to throw out there, I know we're all aware of the budgetary constraints that the agency is under, and staff taking on multiple different roles and responsibilities. And I have started, I sort of want to put this out there to the board, just thinking through what we can do as commissioners to just to ensure that we're not stretching people thinner than they already are. So that's just a comment. You can tell by the way I'm saying it, it's a very fresh, not fully baked just yet idea, but I will plan to come before the board again, just thinking through some actionable items that we may be able to take on.
Commissioner Concepcion, I appreciate that. Anytime I call one of our staff, I'm always, first of all, we know how busy they are, but obviously I think we're all sensitive to adding anything else to their plate. So it's a sensitivity, I think, shared by all of us. How do you vote?
Aye.
Okay, thank you. Commissioner Roy?
Aye.
And Commissioner Stebbins votes aye, 4 in favor, none opposed. We are adjourned. Our next meeting will start at 4:30. So we have some time for a quick
I
break.
do believe people need
Yeah.
to make sure that they're using the new link in the other agenda.
Yes,
Thank you.
correct. Thanks.
Thank you, everybody.
Thanks, everyone.
Yeah.